Good morning. I, Parush Sood, on behalf of the Technology Transfer Group, would like to welcome you all to the Intellectual Property Rights Workshop on how IP impacts life, organized by the Intellectual Property Rights and International Relations Cell, sponsored Research and Industrial Consultancy, IIT Kharagpur, in association with the Rajiv Gandhi School of Intellectual Property Law. So to begin with, I would request the audience to keep their mobile phones in silent or switched off mode. Thank you. I request Honorable Justice Aniruddha Bose, Judge, High Court at Calcutta, to come to the dais, receive the bouquet and take their seat. Honorable Justice S. Ravindra Bhat, Judge, High Court at Delhi. Professor Sudhir Kumar Barai, Dean, Undergraduate Studies, IIT Kharagpur. Professor Goutam Saha, MHRD IPR Chair Professor, IIT Kharagpur. Professor C. Retna Raj, Professor in Charge, Intellectual Property Rights and Industrial Relations Cell, IIT Kharagpur. I would now request Professor Goutam Saha to give the welcome address.
Good morning. So welcome to this workshop. And this particular workshop is directed towards how intellectual property impacts life and extra emphasis on electronics research fraternity. And we have amongst us, you have already seen the schedule in 3 sessions: inaugural session, session 1, session 2. Esteemed guest, speakers, experts, Honorable Justice Ravindra Bhat, Honorable Justice Aniruddha Bose, Professor V.C. Vivekanandan, Professor Imtiaz Gulam Ahmed, and one expert from industry, Mr. Vineet Rohilla. He will be coming and addressing all of us in this particular workshop. You all know that IIT Kharagpur is an institute which is in the forefront of not only technology development, also making its mark in intellectual property related studies, research. So we have a unique blend in this particular place where technology and IPR law, they merge together in some sense. So the expectation from IIT Kharagpur is a little bit more compared to other technology institutes. And again, if you look at the IPR or law schools in other places, the way they deliver to the community, compared to that, our law school, the expectation from the researchers, scholars, faculty, the expectation is again a little bit different, and the technology and law, this merging needs to take place. There is one occasion from the registration that what we find that we have good mix of law school fraternity as well as technology fraternity participating in this workshop. Welcome to all, and we want that you interact with each other also and see how you can take the activity forward. You all know that we have recently got the award of National IP Award 2 years back. And we would like to continue to do good work, working together. As I said, we do not want to, the sharing of campus of law school scholars, law school students and technology students, that is a unique experience here. So we want to take it forward and look forward to a great session, great workshop. And let us see whether we can beat earlier benchmarks and make the most out of our interaction. Thank you.
Thanks a lot, sir. Now I would request Justice Aniruddha Bose to share a few words with us.
Thank you. I think this is a non-scheduled talk. Brother Justice Bhat and all other dignitaries present. As looking at the subject, how intellectual property impacts our life. Underlying reason possibly is that what we do after that, when we know in what way it's impacting life. Is it impacting our life too much? Are we creating too much intellectual property? Or are we ignoring something of value and not giving it the recognition of protectable property? There is a session of mine in the second half where I will discuss on this. Thank you, the Technology Transfer Group and the Law School for organizing this kind of a workshop, because now technology is become it's improving the quality of our life daily, and you cannot avoid law also, because law is being used in various ways, either to liberate technology or to enclose it. So we must know the legal technology for proper utilization of scientific technology. This is where both the faculties can join together and evolve some kind of model at the theoretical level and also in some areas at the practical level. Thank you. I was asked to keep my speech short, and I'll be a bit longer in the second half.
I would request Professor Sudhir Kumar Barai to share a few words and also introduce Honorable Justice Ravindra Bhat to the audience.
A very good morning to all of you. Welcome to the workshop on how intellectual property impacts the life. Honorable Justice Bose and Honorable Justice Bhat and all the faculty members, the students, community here, and all dear friends. As you know, actually, I just want to start with a little lighter vein, and then I'll get into very quickly to the importance of this particular workshop. Everybody in their childhood remembers the neighbor auntie makes a nice pickle, and that pickle is a trademark pickle, which you don't like any other person's pickle, but you like the pickle of the neighbor auntie's pickle, because she makes it in some special way, and that is something which is a trademark about her. That is something which is very intellectually enriching ideas which has gone inside making that pickle, and that we always cherish about it. Same is when the students who are living in the hostel, they like to go back home and have food of mother's recipes. Why? What it makes different? Because the ingredients which used here are the same, and the ingredients used at the home are the same, but the product is different. And that is something, now there's a trademark also. The trademark also. So and mother's some extra love makes that special thing. So that is something which makes it that even in a smaller way, it really impacts our life. Whatever way it would be, but it really impacts our life. Coming to a very serious note, let me just tell you, in this house we have undergraduate students, the postgraduate students, and also the law school students. This technological institution, as Professor Saha has said, it's in a place of technological, the law, medicines, and everything exists together. We have a raw human intellectual property here. We need to channelize this energy. And this channelizing this energy and converting them to create a better and higher impact to the outside social life. That is our role here. And that is one of the reasons this particular workshop has a very important aspect of it, to contribute towards it. The way environmental sciences subjects are taught in undergraduate level, now it has gone to the school level. I personally feel as a Dean undergraduate studies, the time has come now that every individual in this house must know the basis or the basic fundamentals about the intellectual property rights and how it can impact to the life in terms of not only the well-being of the society, but at the same time, your well-being about you. You can, now people talk about the entrepreneurship. People talk about starting their own companies. Ideation till the product, that is the now demand from all IITs. And that is where you people will contribute, you will create an opportunity for others, you'll create a better life for others, and that's where the impact of the life will come into picture. So I just have the request to all of you to participate very actively. You are very lucky people, very honored people that you are going to have wonderful speakers who are going to share their experiences. And at this point of time, I would like to introduce our first speaker for the inaugural session. And it is indeed a great pleasure for me to introduce the Honorable Justice S. Ravindra Bhat. He finished his schooling from the Central School, Faridabad, and thereafter completed a graduation in BA Honours in English Literature from Hindu College, Delhi in 1979. Then graduated in law from the Campus Law Center in Delhi University in 1982. He then enrolled with the Delhi Bar Council in August 1982 and commenced law practice in the same year. He practiced before the Delhi High Court, Supreme Court, and before various other judicial fora. During the course of law practice, he had exposure in different branches of law as public law, the banking, education, labor and service, and indirect taxation. He became the permanent judge of the Delhi High Court on 20th February 2006. It is indeed a great pleasure to invite Honorable Justice Ravindra Bhat to address the gathering, and we look forward to have an exciting session from you. Thank you very much, and please come.
Thank you. Good morning. Justice Bose, Dean, Professor Saha, Professor Raj. I see a lot of distinguished faculty here, Dr. Vivekanandan. I see the Dean there, and I think Professor Raju. It's indeed an honor and a pleasure both to be asked to speak in an IIT. I've always looked forward to interacting with minds which I gladly acknowledged are far superior to mine. To be able to handle trigonometry, algebra, was something which I parted company with at the end of my 8th standard. But it came back because when I started dealing with intellectual property, the first case that I had to deal with was a complex patent one. So it was a crash course in many things that I had given up. So that, I think, is the beauty of challenge of law and academics. The topic for today's morning session is more or less an introduction to intellectual property law. And I think I'll take up the good professor's example further. What makes the pickle, the mother's pickle, what it is? It is the ingredients, it is the recipe. Now, in the heart of that lies a dilemma. Would your mother or would the neighborhood auntie like to enclose it? Now you are all aware of property. What is property? It is tangible property. It could be a movable product. It could be some product like a mobile phone or a computer. It could be immovable property, which is land or buildings, etc. Now we all understand that when you own some property, intangible material, you can actually control it. In terms of land, you have possession of it. So, yeah, and you know what you're in for when somebody disposes you of that land and trespasses into the land. That's brought out very vividly in a very good movie, Khosla Ka Ghosla. So that is what happens when you're dispossessed of it. You know, you can see that your property has been trespassed. You know your property is stolen. intellectual property deals with intangibles. Now, what is intellectual property? Is it something very esoteric, something which is all that intellectual? Well, there is a lot of intellect to it, but so is there intellect to the property, tangible property. But what distinguishes here is that these are concepts which afford you protection for the product of your imagination, for the fruits of your labor, and the way you have expressed yourself for that effort, for that toil. So when the pickle comes out, you have a recipe. It could be protected as a trade secret. We don't have a trade secret law, but it is recognized in our common law. So if somebody tries to steal it and exploit it commercially, you can go to the court and stop that man or woman. The other way is if you yourself want to commercially exploit it, or you do not want to you want to prevent somebody from commercially exploiting it, and you are actually in the trade, and you're calling it X pickle or whatever, and the other person is also trying to use the X mark and trying to literally pass off the pickle as his own, then you can prevent him through trademark law. Either through a passing off action if this is an unregistered trademark, or if you have registered it through a trademark infringement suit. The third enclosure possibly is if you have written an article or a blog about that recipe. That becomes copyrightable. You don't require a registration. You own the manner that you write. Copyright is not about property in ideas. It is about the right to the expression, the uniqueness of the expression that you have put down in that article. So the words that you use are uniquely yours. The way that you have expressed is uniquely yours. So your scientific articles are copyrights. And then we come to the high concepts of patent, which is that when you come out with an invention that is protected widely in an almost monopolistic, it's a monopolistic property right, which confers you exclusive right to prevent someone from making that article unless he or she acknowledges your right over it and takes your license. Now, many of you are students of law and many are not. I assume that many are not. Our constitution recognizes various rights, various fundamental rights. You have the right to free speech, you have the right to freely move throughout the country, the right to life itself, which the Supreme Court has expanded to say includes the right to housing, right to basic medical service, shelter, emergency health care, right to equality, and so on. One of the rights which the constitution makers initially gave to the citizens was property rights. This property right was deleted in 1978 through an amendment, and yet it has been relocated, so as it were, in some other part of the constitution. So the Supreme Court recognizes that you have property rights, though they may not be fundamental rights. And in one judgment in 2011, the court said that even these property rights includes property in intellectual, that is, intellectual property is also a species of property over which you have rights. So intellectual property can be transferred. For instance, you own copyright, you can pledge it. You can license it and commercially exploit it. You own patents, you can pledge it and raise a loan. You can sell it and make money, and so on and so forth. So it has all the attributes of ownership of any property. So what is intellectual property law? One should never oversimplify it, but to the beginner I would say that it is the attempt on the part of society, like in all other cases, to bring some kind of an order, a balance between the extreme rights that a property owner will exercise. Supposing I own copyright, and I can give an example. There was no copyright law. When the printing press became an invention, it became a reality. So the printer who actually commissioned works of, fiction or whatever, the printers started saying we have eternal rights. We will decide whom we will give the books or publications to and for what period. Because there was no copyright law. And I think this is a judgment of 1771, am I right? So then you see one of the uniqueness of the British institutions is that the House of Lords, which is the second legislative organ, was also a part of the House of Lords, was also the judicial organ, highest judicial organ. So the full house of the House of Lords, of the Judicial Committee of 31 judges, they decided that you cannot have eternal rights. And they said that there is a finiteness to the extent you can claim copyrights. And that is where the limit of a copyright was born. The idea of a right being curtailed in point of time was born. Therefore, now, to start with, when the copyright laws, I think, came about, and Mark Twain was one of the prime movers because he was an author. He was the prime movers to the convention, Paris Convention. Those days it was 50 years. Nowadays, they've, by a peculiar amendment, which is called the Mickey Mouse Amendment, it was extended to 70 years. 70 years from the date of the work and after the death of the author. Likewise, patents are there for 20 years. So the trade-off, the law actually defines the trade-off between granting of the right and the public good. In the case of an invention, let us take a medical invention. The state confers that monopoly to you for 20 years. You can use it, exploit it, and make money. But after 20 years, it is for the common good. And it can be used by others to make other inventions. And that is the trade-off between the public interest in ensuring that there is technological growth and continuity in thought and innovation, and the public interest in rewarding invention. So this is the most important part of the intellectual property universe, which the law is supposed to take care of, and which lawyers and judges are supposed to be involved in. This aspect was described by one judgment in a very nice way. It's a division bench, 2 judges of the Delhi High Court way back in 2011. They said that from a jurisprudential point of view, intellectual property rights work as a two-way sword. On the one hand, there is a growing awareness that such protection is a sine qua non of the motivational factor underlying creation of an intellectual work. However, on the other hand, granting an absolute protection to the intellectual work can be detrimental to further progress of humanity. In order to balance the rights of the author on the one hand and the society on the other hand, certain limitations have to be made a part and parcel of IPR statutes around the globe. In the realm of copyright laws, one of the more important limitations is the doctrine of fair use. This doctrine of fair dealing is a limitation and exception to the exclusive right granted by copyright to the author of a creative work, and it allows limited use of copyrighted material without acquiring permission from the rights holders. Now, I think the time that I have, 30 minutes, is too short, and I do not intend to make this a kind of crash course introduction into IP law. I'll just flag some important concepts which I think should serve as an introduction to you. We have we talked about 3 important intellectual properties. One is patent, the second is copyright, and the third is trademark. And if I'm asked to summarize what drives these 3 concepts or 3 principles or 3 broad heads, I would say this. In case of patents, it is a trinity. 3 concepts: novelty, non-obviousness, and industrial application. Novelty. What is that element which is new, which is different from what exists? There are, of course, it's not as obvious and not as simple as that. But at the heart of patent law is novelty. an invention, in order to get protection, has to be novel, it has to be unique, and it has to have what is called as an inventive step. There are a series of loops that an invention has to go through. I would just briefly describe the process as: how do you find out what is novel in your product, or what you have developed, or what is unique in your product as compared to the other like products which exist in the market or in the field, relevant field. There is something known as prior art. What exists in the field is known as prior art. Now, this is not art. Essentially, in technology, it is science. What exists is writings. What exists is writings about patents. What exists is improvement of patents, which all exist in the public domain or which have been granted patents. This is known as the prior art. In other words, the entire repertoire of literature which exists for that relevant technology or field. So the test is, if looking at the prior art, an ordinary person skilled in the art would be a scientist or an engineer or someone who is able to develop the application. If an ordinary person skilled in the art is able to put together the invention that you claim is novel, then it is not patentable. Because that which anyone can do by just putting together something which a normal man with normal imagination can do should not be protected. It should be left to be used by humanity and the public as it is. That is where your inventive step becomes important. If you can show an inventive step which is unique, novel, which no ordinary person skilled in the art can actually arrive at, you have cleared the first stage of showing novelty in the invention. Then you have to run the loop of certain other things, that it is not anticipated, it is not obvious. All this, there is a lot of overlapping in these concepts. And then, once you have passed through this gate of novelty in an inventive step, you should not fall in the list of exclusions. Our law has a long list of exclusions, what cannot be patented. There may be inventions, they may be unique, yet they cannot be patented. And one of the most important of these exclusions was introduced in 2005 through what is known as an explanation to section 3D, which is also one of the most controversial, most contested till date, and a lot of judgments have been written about it, which is in the field of pharmaceuticals and chemistry, a new molecule which is developed by an inventor is deemed to be part of the older molecule which exists, to which it is related, provided it does not show if it shows greater efficacy in what it claims to be, then and then alone is it given patent protection. So you may develop something new, it may be a derivative of something, and yet it may not be an invention unless you can show that in its effect, in its result, in what it seeks to achieve, it has greater efficacy. So this has been very contentious in the pharmaceutical field, and the courts have interpreted this. I think there are at least 5 or 6 interpretations by various courts. The Intellectual Property Appellate Board, which is a specialized body, that has also interpreted this in the context of pharmaceutical inventions. Even the Supreme Court had occasion to deal with this. Important in this field of exclusions are concepts like mathematical formulae, laws of nature. I think anything to do with plants or animals, those are excluded, broadly speaking. And in some cases, there are special enactments like the Plant Varieties Act, where you can get certain different types of intellectual property protections. These kind of exclusions do not exist in certain countries like US. In the US, patent can be granted literally for anything under the sun if you can show that there is an inventive step. But in a developing society, And having regard to the fact that for a long time our intellectual property regime, law regime was different in the sense that we did not believe in granting protection to certain types of invention, we have chosen to keep a hybrid kind of a model where certain exclusions are still there, and they regulate, even if they regulate and prevail, even if you get to invent something. For instance, something that relates to national security, possibly you will not get a patent. Then this is subject to another, once you get this right, what can you do with it? Essentially it is a negative right. If you look deeply, even a property right is a negative right. You own a house, whether you use that house or not is your business. You can keep it locked. You own an appliance, how much you use it more than your neighbor or less than your neighbor, or don't use it at all. The mere possession of it and the purchase of it grants you that right. So it doesn't matter that you use it or don't use it. So, but when it comes to the right to a process, to grant the right to someone else, you have the exclusive, right to say, I'll grant you, I'll permit you to produce, let's say in the case of patents, I will allow you to produce 10,000 pieces of this for 1 year. That is the license, that right to license. And in the case of copyright, it is even wider. You write a song, and I'll come to the copyright is a very complex concept, and some of your professors will later tell you. There is a lot of nuancing in this. You write an article that becomes a storyline for you could even be a screenplay writer. You write that, and you also write the songs for a movie. So in that one movie, there can be many copyrights. You could have a copyright over the story. You could have a copyright over the whole movie. You could have copyright over the songs. And you could have copyright over the sound recordings. See, each one of them is exclusive. So you will have to give license to someone who seeks it for each of these different copyrights. And each one can have a different species of, its own direction. For instance, you own a song, or you have got a sound recording. One manufacturer comes and says, and he negotiates with you. You arrive at a price. You say, I will allow for this price you to produce and market 1 lakh DVDs in Bengal, but nowhere else. Now you want Blu-rays, it's another story. I'll negotiate and dictate another price. That will be a different license fee. You want to go to the rest of India, it could be different. So the property rights are nuanced. Then you have digital rights now. So each one of them flows a different pattern, so that confers the property owner with the right to dictate his terms. That is the way the law has taken shape. Now, how do you balance this, as in the case of patents? Considering that you have 70 years as a right. Now, this is where certain concepts in copyright law, like fair dealing, come in. For instance, you have a telecast of a song without permission. Now, you have a song which runs into, let's say, 10 minutes. Now, someone borrows a part of that, maybe 10 seconds or 20 seconds, lyrics of that, or maybe even the score of that. The question, and then he makes his own song. That becomes an adaptation. So the question can be, would that so-called infringed part amount to a violation of the copyright? Now, even here, there is no black and white, there is no bright line. It all depends on what you have taken. For instance, I think one of the famous controversies was, you're all aware of that famous movie, Oh Pretty Woman. So Pretty Woman started with this theme song, Oh Pretty Woman. Now that Oh Pretty Woman, somebody appropriated in a song as part of his or her song. Now, that becomes a copyright infringement because the quality, that what defined that song in Oh Pretty Woman is virtually lifted here and copied. Whereas you take a small part of a lyric, which is not prominent, may not be a violation because it is a fair dealing. Likewise, when you extract from an article, a part of the article, it could be a copyright violation, it may not be a copyright violation. Depend on, first and foremost, do you attribute it? Do you give credit? And secondly, how much of it is part of the core of your article? So all these are seen by the courts to determine whether there is a copyright violation. And when you come to manufacture of songs or creation of films, etc., similar tests are made. The other concepts in copyright include, for instance, transformation. When you are using one concept, after all, knowledge is dynamic, knowledge is never static. What you are taught today is from a textbook. I'm reminded of a quote from Bernard Shaw. Bernard Shaw said that where I stand, what I can see, and what I can think of and talk, I'm superior to Shakespeare. So people said that here comes a very arrogant man. He thinks that he's superior to Shakespeare, one of the greatest, the bard and one of the greatest playwrights and poets of the language ever. But what he said was, knowledge is incremental, which means that when I stand on the shoulders of Shakespeare and I stand above him, I have the benefit of what he said. It is not to say that I am superior to him. So knowledge, information and education is dynamic. What each succeeding generation is better than the other, the previous one, in terms of what it assimilates from the previous ones. So it is a continuum, a continuing process. So copyright law has to and does provide for this in concepts like fair dealing, adaptation, and then what we call as transformative, works. You may assimilate concepts from a previously published article and also add your own. The question is, how much of the previous copyrighted work is yours and how much of yours is imposed over it, so that the identity of the previous work pales into insignificance. So this ensures that there is continuity in information dissemination, and at the same time there is protection of copyright and growth. So much for copyright, and I don't intend to bore you with technicalities which are there in copyright law. Both in copyright and in patent, there is one interesting, let's say, a safety valve. And India is unique in terms of that safety valve for patent law, because even America doesn't have it. You see, our patent laws were changed because we subscribed to TRIPS. You're all aware of TRIPS? So we had to necessarily change our laws because of our entry into TRIPS. And that process started in 1995 and ended in 2005. So one of the TRIPS, what is known as flexibilities, is that you can have a system of compulsory licensing. So we are one of the few countries which allow compulsory licensing. Compulsory licensing simply is this, that there is a product which is useful to the public. That product is not gaining wide acceptance in the sense that it is not widely accessible to the people. Let us say an essential drug or a very useful appliance in the technological field. Now the technology owner or the patent owner or the drug company wishes to import the goods or put them on sale in a limited quantity. They don't want to make huge profits in India. They said, we don't want to get into this huge problem. But they start it. Let's say they sell only very limited quantities of that product, maybe 10,000 pieces. I mean, I'm talking of an actual case. 10,000 tablets or 10,000 packs or doses of a particular drug are sold. that is a life-saving drug, which can actually save maybe people who are suffering to the extent of the people who might actually benefit from that at that given point of time could be 1 lakh. And this happened in the case of a cancer drug. The company was Bayer, and compulsory licensing affords a drug manufacturer the facility of first asking the patent owner, please allow me to manufacture this at a reasonable rate, give me a license. If the license is not given, then he can approach the drug control, the patent controller. Of course, one condition is that this application cannot be made at least for 3 years after the grant of the patent. But subject to these limitations, you can go there, and the patent controller then can inquire as to the cost of production, what is the reasonable rate of return which the patent owner should be given, and then say, this is the price at which you must sell. Now, in that particular case, Bayer was selling this drug at, I think, something like 2.5 lakhs per month, a dose of 2.5 lakhs per month. It refused to grant license, and in the proceedings it refused to open its books. So the the patent controller determined the price at 8,000 per month. Well, there could be controversy as to why 8,000, what is the reasonable rate of profit? What did he take into account? Unfortunately, Bayer did not participate and it refused to reveal its production cost, reasonable rate, what all went into the 2.5 lakhs. So therefore, just the plain production cost plus whatever 15-20% profit was determined and fixed at 8,000. We have to see progress in that, in the sense that we have to understand what constitutes a return. After all, when you go in for an invention, there is success, there is also failure. So how much of the failure can you recover from a successful invention, from the clients of a successful invention? These are controversies which will be explored in the future. But compulsory licensing is there in patents. Likewise, there is a compulsory licensing proceeding available even in copyright law. Now I'll come to trademark. Now, I am reminded of a time when, as you have seen, when whatever little was read about me, the little achievements that I have, I had no grounding in IP law at all. I was mostly a public law lawyer, in the sense that I did rate work, I did a lot of labor and service cases and educational cases in the higher court. So I had no exposure to intellectual property law. So, and I did not think much of trademark law. So when the case of a very important brand came up, I said, more with contempt than with conviction, that what is intellectual about trademark? Well, the point is, you can't really say intellectual, but it's branded as part of the intellectual property law, and it is a very powerful one. I'll throw some names to you and you will realize why. What comes to your mind when I say apple? You don't see the red apple. Maybe you do, but there are only two things that come to your mind: apple and the Mac. Likewise, what comes to your mind when I say Mont Blanc? It's a luxury item, of course. Mont Blanc is actually a peak. It's a French peak in the Alps. And yet, the primary meaning, which is Mont Blanc, the mountain, is actually subsumed by the product of the luxury pen that we are so familiar with. And likewise, many of the things that we see today are what are very powerfully sometimes advertised marks. Sometimes they have captured our imagination and imprinted it themselves. that we are unable to go back to the first meaning, the primary meaning of the term. Now I'll give you an example. I had occasion to deal with a case relating to Scrabble. Now Scrabble, they claimed a lot of things. The Mattel, which is the company which owns Scrabble, the game, they claimed a monopoly through copyright over the board. They claimed monopoly through the lettering and the alphanumerics, and then the rules of the game. Then they claimed some design monopoly. In my judgment, I denied all of them because rules of a game are not copyrightable. Mere combination of words, letters with numericals cannot be copyrighted because it's part of the common heritage, the common knowledge of people. So what is known as an idea expression. If there are only very few ways of expressing an idea, then it is not copyrightable. That is a concept in copyright law. And the board is just a random, fixation of colors. But then I upheld the trademark claim. Why? Because those boys, the infringers, incidentally, they happen to be from Calcutta. They were using the word, not Scrabble, they were using the word Scrabulous. Now, Scrabble is a dictionary word, but I don't think, I didn't know what is that dictionary word. And I don't think half the people sitting here know what does Scrabble originally mean. But yet we know Scrabble as a game. Therefore, there are certain words, maybe in the common language, which are associated with very powerful symbols. Shortly put, the trademark is a device. It could be a word, it could be a combination of colors, it could be words and colors, or a design which signifies to the consumer the product or the service and the quality of the service. So when a manufacturer who produces some article puts it in the market and brands it with a mark, you associate that mark with that product, not just the product, the quality of that product. So when that mark is appropriated, or rather the idea of the mark is stolen and used for by some other man for the same product, he is actually trying to say that this is that product, and the consumer doesn't know, he thinks it is the same, whereas the quality is different. So this is a direct appropriation of an idea in that sense. And what is important here for a trademark, unlike in the case of copyright where it is originality of expression, or in patent where it is novelty, here it is distinctiveness. The distinctiveness of the mark and its association with the quality of the product or the service. Usually we have a direct relationship between the product, a particular product line. For instance, I talked about Apple. If someone uses Apple and starts making clothes and selling them, what would you say? Supposing somebody uses the word Apple or uses the Apple device for a clothing line, what would you say? You'd say, what is wrong with it? Not so for the Apple man, not so for Mac. There is a concept known as tarnishment or which is the other one? Not disparagement. Disparagement is a trade. It's a tort. Dilution. Sorry. Yes, dilution. And one of the first dilution cases came to the Delhi High Court about 25 years ago. Benz. The Benz mark and the Benz logo was being used for an undergarment which was being sold in a small shop. So people would say, what is wrong if the Benz mark is sold? Because Benz, how are Benz sales hurt? At one level that is true. The sales of Benz would never be hurt if a small time garment manufacturer in Karol Bagh uses the mark. But it is not that particular instance. You allow that to happen, you don't know where it would end, because then the Benz mark could be used for a variety of products, and the consumer may be left thinking that these are all Benz products. So the Benz man will never allow that to happen. So even though Benz is in relation to cars and such like, accessories and other products, it is so important and so famous for them that they would not allow it to be used for a diverse range of products. So dilution relates to diverse range of products and not the primary product line of the trademark owner. I don't know how much time is there. I think I'm running. Do I have some time? Yeah. I've spoken about patents, I've spoken about copyrights, I've spoken about trademarks. But there are other kinds of rights. You have design rights. Now, designs are similar to patents in the sense that you have to have novelty, uniqueness, and there has to be an aestheticness to it. Designs relate again to products, but they have nothing to do with the you don't have the inventive step which you find in patents. There's an intersect between design law and copyright law, in the sense that designs can be copyrighted, and those copyrightable works which should be enclosed in a design should go in for design. If you do not do that, you lose the copyright too normally. But there's a very important exception here, and that's where this intellectual property becomes a very subtle and nuanced, very interesting study. For instance, you have let's say a very famous painting, like say Mona Lisa, or let's say a Mickey Mouse. Mickey Mouse is a copyrighted work. Now, Mickey Mouse is used on 3-dimensional articles, or it is used for, let's say, pencil boxes for kids, which usually happens, and somebody actually gets a design registration for that. At the end of the design registration, can it be said that the Mickey Mouse protection is lost? No. Mickey Mouse could be a work of art, and therefore it is entitled to protection. Likewise, a painting which is entitled to protection as a copyrighted work, the primary work will continue to get copyright protection, even though the design exploitation of that through an exclusive design may cease after 15 or 20 years. Now, this overlap is very necessary. This overlap happens between design and trademark. It happens between trademark sometimes and copyrights, because trademarks involve both works of art which are copyrightable and distinctiveness. So copyrights may exhaust themselves, but trademarks will continue, because trademarks can have combination of colors, lines, etc. And there are certain other types of rights which are recognized more or less as intellectual properties, which are publicity rights. For instance, someone like Amitabh Bachchan. Mr. Amitabh Bachchan is a name. Now, Amitabh Bachchan's personality, these are called as personality rights. His personality, he has a right to control the commercial part of his personality. Now, one has to understand two things here. There could be both a freedom of speech issue and an issue of commercial rights. You want to speak about Amitabh Bachchan, nobody can prevent you. Something he does or says, you want to criticize or appreciate, nobody can. Mr. Bachchan cannot say you cannot do that. But the moment you use his personality for some program which is used commercially, in the sense that you use his personality in let's say as a figure in a movie without his permission, you're exploiting it commercially. He can prevent you. Again, the free speech part of it could be you want to lampoon him, you want to parody him. It is possible. You don't need his permission because you have free speech rights. But anything to do with commerce, which exploits his personality, he has a right to control it. And sometimes it could be even a matter of privacy. Of course, it's a very controversial topic right now, whether we have right to privacy, etc. But at least in terms of publicity and personality rights, where it comes to commercial exploitation, you have a right to say, no, you cannot, I don't grant you the permission, I don't want to get into that. Or if I want to be shown, I want to be shown subject to these conditions. These are all developing as yet, and we don't have too much of jurisprudence in that. I would like to end by talking about how much intellectual property can actually implicate lives generally. The manner in which you enforce intellectual property is through injunctions, civil suits and injunctions, through damages, and so on and so forth, which are traditional remedies. But of late, the courts have been using interim remedies to send, local commissioners in what are known as Anton Pillar orders to seize the goods of trademark infringement goods or copyright infringement goods, and then work out the damages. My court, the Delhi High Court, has been in the middle of this controversy for a long time, for about 3-4 years. So these kind of orders have been criticized. I would not venture to give my opinion except to say that I am very careful while making any order, including interim orders, because I do realize that you arm a private body or a litigant to go into someone's house or someone's property and seize other properties or goods. You don't know the degree of harm that will follow. And I got sensitized to this because in one copyright infringement case, where the allegation was that computer software, unlicensed computer software, was being used, commissioners were appointed through my order. They went and sealed a lot of computers. It turned out that it was a BPO which was supporting some medical service. Now, if we are not aware of these things, there can be very harmful consequences. So after that, my orders were more careful. I never allowed seizure and sealing, wholesale sealing of any computer or any premises in that sense. But then I suppose this is a part of a continuing debate, and we'll keep improving ourselves. To me, what interests most, and coming from where I am, which is my background has been more of a public law lawyer and then a judge, is the intersection between intellectual property law and public law. IP laws and public law have these very crucial intersections. Practitioners and courts have to be alive to this aspect. These intersections may affect lives and healths of large multitude of people who are not only third parties, but not within the contemplation of litigating persons, but even the courts. So even courts may not be aware of these third parties. So when you stop through an injunction the sale and production and sale of a drug, you don't know what is the consequence of the user of that drug. There may be, in some case I found out there were 50,000 users of that drug. And not all would have been able to buy the patented product. Patented product was priced 3 times more than the infringing product. So if you stop the infringing product, access to the cheaper drug would go. But then how do you say that this is more important than other products? So then some of us have tried to reason it out by saying this is a life-saving drug. That which is not a life-saving drug but more of a lifestyle drug, let's say a cure for baldness or something of that kind, you can do it. But that which is a life-saving drug, if you stop it, who takes the responsibility later? Because a life lost will never be compensated. This has been frequently observed in drug patent related cases. Then the other controversy is in copyrights, and again the Delhi High Court recently was in the heart of that, and I think it's reached the Supreme Court. Sale of guide and textbooks throws up challenges between copyright proprietors on the one hand and access to knowledge at reasonable cost. Similarly, access to news in the public domain may be effectively blocked as hot news or other IP sounding right. Even the right to report can be chilled on the pretext of commercial exploitations. Sometimes even a simple ant and pillar order may result in sealing or shutting down an essential or crucial service. The offensive action may be even a satirical piece or a comic strip. A parodic use of free speech right guaranteed under the Constitution may be unwittingly jettisoned by courts in the course of an injunction suit. The courts increasingly have to therefore be aware of these constitutional rights and public interest concerns which conflate with private property rights. The word here is balance. The task which the court is entrusted with is not an easy one. It is increasingly evident that public law interfaces in so far too many ways that we have examined. Access to essential drugs, inaccessible copyrighted works and fair use. FRAND is essential technologies. In one of your later sessions, I think you will have an introduction to that, probably in the technology session. FRAND means fair, reasonable, and non-discriminatory pricing of patented products. Will be to be used for essential technology, limitations on free speech through enforcement of trademark rights. Frequently, these issues confront courts. Robust interrogation of principles which protect property rights and how their judicial interpretation implicates the larger general public. Yet in every sense, in every case which presents itself with some complex feature, a delicate and balancing exercise should be conducted. And this is what John Stuart Mill said: the only freedom which deserves the name is that of pursuing our own good in our own way, so long as we do not attempt to deprive others of theirs or impede their efforts to obtain it. Thank you.
Thank you, sir. It was an honor to hear you. May we have Professor Barai give a small token of appreciation to sir? We at Technology Transfer Group aim to promote IIT Kharagpur as an active research consultant and also promote research among the student fraternity. Sharayu and Ane will give a small presentation on TTG and its activities.
Honorable judges, respected guests, dignitaries, and all the audiences, good morning to you all. I am Ane. I am a head in a technology transfer group. So today I'll be giving you a brief of what TTG does in actual. So at TTG, our main focus, main priority is closing the gap between industries and the research. You might see that normally when you research, a lot of new ideas come up, but they are not implemented in actual real life because there is a gap between the patenting and all. So that's why it is not in actual production. And on the other hand, if a company needs something new innovation, but they don't get a new research so that they can implement the new idea in the product. In the both the ways, there is a gap. So we at TTG aim to close this gap. TTG is basically a student body under SRIC, a sponsored research and industrial consultancy, IIT Kharagpur. We act as a link between industries and researchers to industry to file the so that the industrial technologies, the ready industrial technologies will get into industries. And our major aim is to promote IP awareness and to increase awareness in students so that patents will be filed more and more industrial collaboration will be there.
Good morning to all. My name is Sharayu. I am a student head from Technology Transfer Group. Every year, Technology Transfer Group organizes IPR workshop from inviting distinguished speakers consisting of honorable judges, patent attorney, academicians and industry experts to impart fundamental knowledge of intellectual property and provide insights of various intellectual property rights to the student community.
As a research institute, one of the most important IP is patents. And TTG plays an important role in increasing the patent count of the institute by conducting patent drive on a yearly basis. In patent drive, what we actually do is we approach a lot of researchers in a campus, and the potential inventions are then forwarded to the IPR cell through our IP portal. From the IP portal, the IPR cell gets the invention. Then they are evaluated with the help of various reviewers from various departments in the institute. And if that is a good innovation, then the further processing is started without any cost to the researcher.
One of the ambitious initiative of Technology Transfer Group was 100 Days 100 Patents, which reached its filing target successfully and earned IIT Kharagpur the National IP Award 2016 as the top Indian academic institution for the patents.
Another step in this closing the gap between industries and the research at IIT Kharagpur, TTG also represents the research at IIT Kharagpur at various international and national events. One of the research example is the IETF, International Engineering and Trade Fair, which was conducted by CII at New Delhi this February. We presented IIT Kharagpur there. And also the 2014 Indo-US Summit, the TTG also played an important role in presenting IIT Kharagpur.
At Technology Transfer Group, we celebrate the concept of novel idea which any innovation and development that mankind has ever done. TEDx IIT Kharagpur is one such event which takes us on the journey of realizing the beauty of this concept. Speakers from different walks of life filled with enthusiasm and passion towards their goals are invited to this event to share their bright ideas with us. We had great speakers such as Nobel laureate Mr. Kailash Satyarthi in our previous editions of this event. We'll continue this journey with full enthusiasm and passion and responsibility in establishing IIT Kharagpur as a premier research consultant for industries under the guidance of Dean SRIC and Professor in charge IPR and IR cell. Thank you.
Now we will have high tea and resume after 10 minutes. Please help yourselves with tea and light snacks provided outside the seminar room.
Yeah.
Welcome back. IIT Kharagpur witnesses a plethora of great inventions every year in the departments of computer, electrical, electronics, telecommunication and mechanical engineering, to name a few. Keeping this in mind, we now start our first session. This session is themed Getting Patent, the paradigm of computer, electronics, electrical and telecommunication. I would call upon Professor Kushal Vibhute, Head, Rajiv Gandhi School of Intellectual Property Law, to chair the session.
Good morning to all of you. Professor Goutam Saha, IPR Chair, Professor C.R. Rao, IPR IRPIC, my friends from law school, students, my friend I.J. Ahmed and Professor Vivekanandan. This is a unique pleasure to call upon two speakers for the first technical session. Professor V.C. Vivekanandan, who is the Dean of Law School, Bennett University, Noida, and he is my close friend, so being a sessional chair I have to introduce, but you can feel touch of a friend, but difficult to introduce him to the audience. but being a sessional chair, I have to give some glimpses of his personality. He is a dean right now, Bennett University Law School, founder dean. He did PhD in IPR. His master degree in field of corporate law and public administration. He started his teaching career from National University, Bangalore. Then he moved to Nalsar to head the Proximate Education Center, and before he moved to Noida, he was MHRD IPR chair in Nalsar University. He is adjunct professor in Buffalo University. His areas of interest are IPR, internet law, artificial intelligence, in entertainment law, and represented India in WIPO and Asia Pacific countries. He participated in negotiation on copyright law in WIPO, and he is one of the well-known academicians in India and abroad who is expert in IPR, particularly IPR in general and copyright and internet law in particular. With these few words, difficult to give a sketch of his achievements as a friend. With these glimpses of his personality, I invite Professor Vivekanandan to be on the dais and give his presentation.
Good morning to all of you. It's a pleasure to be in IIT KGP. The most pleasant part, which I considered my career, Professor Booth slightly forgot about it, that I was the Dean of the Rajiv Gandhi School of Intellectual Property Law and earlier, and that makes me come here. As I said, there was 2 appointments on Friday for me. I had to go from Noida to Hyderabad to meet my wife or to come to Rajiv Gandhi School. They call this as a catch-22 situation, right? And when I hesitantly told my wife, she said, already concluded, I don't think so, you're going to come here. You're going to go to Rajiv Gandhi School. So thank you, she said. So I'm here with you. So even then, today is a bit of run-in in terms of time. So really I wanted to speak little, they had a full quota of time, but I will try to bring the salient features and then discuss this. If I may ask in the beginning itself, instead of asking how many law students here, if I ask how many non-law people are here, that's a majority. So I want to fine-tune myself, because law student discourse is different. So the title was very interesting from your point of view. How intellectual property impacts life. For a very long time, how property was impacting life, that was the discourse for a very, very long time in human history, right? Even communism, Marxism came because how property is impacting life. So that is already impacting life, no denial about it. Add to that how intellectual property impacts life is a very, very, I would call, I don't know whether it's a legal question, whether it's a technology question, whether it's a philosophical question, or combined all of this. So let me first straight away start to you on something with Justice Holmes in one of the very, very early cases said. It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of worth of a work outside of the narrowest and most obvious limits. This was an IP case, on a copyright case, the circus poster case, which Matilal will know much. So there he says, about this. So I also often do believe, being a law person, that it is very, very risky, what you call as leaving everything to law is also a bit risky affair in today's, context. So that is one reason all others have to know about law, whether they are in every other field, and also law which impacts in terms of technology as well as the rights. That is a crucial question. So having said this, as I said, the topic which the first session is about telecom and computers. If you look at players who have been relentlessly filing patents in this country, you have Qualcomm, Ericsson, Samsung, different areas, Nokia, different people with LG, all of them are filing. Seldom we have Indian companies playing around here, because the reason could be we are not in the innovation club. We are more in the what you call a services area. We are more in terms of distribution, all that stuff. That telecom cheapest in India in terms of pricing, in terms of density we are the highest, all that. So it's essentially a beautiful market for a lot of players to do. So, essentially you need to understand little bit I call the politics of law or the politics of every law, that here is a market and then the players who are the innovators are outside, and so generally they are very much concerned about this market and how this market should play according to certain other games and rules what innovators may set in. Then naturally you all know there is a thesis and there is always an antithesis, right, before it becomes a synthesis. So, in such context there will be always something called the other side, which will include in the beginning Indian entrepreneurs, right. For example, there is an association called Computer Manufacturers Association, and then there is Association of Telecom Equipment Manufacturers within India, and they might be very, very wary about what is happening. And then there is something at the end point called the consumers, who may not really love both, whether Indian or multinational, they don't love both, because consumers are generally different people. In the sense, you, me are consumer, in a sense, that we all love everything which is free. Anything which is given free is the first choice, or buy one get one free is the next choice, right, or 12 EMI free is the third choice. You get my point? Or get a guarantee and take some loan and then run away from the place, and the guarantor let him struggle. These are all some of the attitudes of consumers worldwide, I am telling, right. Maybe some exclusion can be some funny fellows called the Japanese, and few guys are very different. Otherwise worldwide this happens. So consumer wants everything free and the manufacturer wants everything to the highest level. So this is the big battle of intellectual property also, in a sense, as Justice Ravindra Bhat gave a kind of a commentary in the beginning, which is easier for me to connect with some specific details when you are talking about incentive versus access. These are the two crucial points. Incentive, without incentive it does not move. Am I right? If I tell you when you join your first year course and tell at the end of the course all of you will get outstanding, whether you study or not, or whether you come to class or not, it is a guaranteed social justice I am giving you. It's a very, very dangerous proposition in education. Unless I have my grades and then you have your gold medals and many of these things, that motivates you to put in the best efforts. So similarly, on the other flip side is that what you call access. So who can afford can buy, who can't afford have to watch. That is a very dangerous proposition, and no amount of free market or capitalism going to stand that, and that is going to be the dangerous revolt which happens. So it's a very tricky business of governments, public policy, to manage incentive on one hand and access on another hand. Both are abstract in one sense. What is the limits of incentive? You ask the innovators, they always will cry, this is not the incentive. You ask the people who want access, they say, no, this is too much, we should have complete access. So this balance is a very easy word, which we see. You must have seen in the Lady of Justice standing with a scale, right? And if you closely observe, it will not be equal, it will be slightly tilted only, right? You ask why, because people tell, how will I win my case? Tell which lawyer you are deploying, I will tell you whether you will win the case or not. Leave alone the other parts of the story, right? So given all these things, I am just giving a snippet to you, and very quickly, as I said, Government of India, okay, DIPP, which is the apex body under Ministry of Commerce, last year was very alarmed about the issues happening in electronics and telecom. They came with a position paper, and the position paper is to develop a suitable policy or framework we do not have, because we are battling very other types of things like health, medicine, all that. This electronics and telecommunication has slowly crept in such fast manner that probably, as you said, as conference or anything, why blame government alone, right? Everything is slightly delayed. So we are now gearing towards what is the framework. As I said, they are really talking about what is called in patents, when you try to read, I don't have time much to explain, what they call standard essential patents. This is one term. Standard setting organizations, which is a technical organization, SSOs they call, and then FRAND, which he talked about, a fair and reasonable way of giving you license. These are the things, non-discriminatory license, all of that they wanted, and that's a discussion paper available which was released last year, and at least they have set the ball rolling about the various issues. So what are the issues as in hand? The royalty payable is a very complex issue. Patent is one part of the story. For example, most of the electronic and telecom we will have some software operating it. In India, we do not allow, but you can have a patent somewhere. So, in a jurisdiction where you do not have a patent, what do? You cover it by way of licensing, contract, licensing terms. So, you do it by licensing terms, and that becomes a complex stuff. Quite often, you will have a very small chip which is part of the innovation, but when you ask for royalty, I am asking for the entire handset what you are selling, and that royalty percentage I want. And if I say no, the technology holders are so strong, somebody will accept. When somebody accepts, somebody else, competitors have to accept. So, there is a lot of players, what I call lower level brand, Micromax, Xiaomi, a plethora of things which is affordable. Morning, Justice was talking about Apple, right? Did you get my point? Apple. So, as I said, those days Apple was affordable. I mean a fruit, but this apple is entirely different proposition. So, given all that stuff, you go for a competitive, except for trademark. Today people tell me that other sets are good or sometimes better, but as you said, the brand differentiates many times. So, you find all of these people are having issues. The royalty is contested now in courts. Most of the royalty, at least in the last 1.5 years, we had about 15 instances of people going to the court. Now, the problem is courts are also not equipped, because without a policy framework, courts are also not sometimes equipped about research part. As you said, you require what's all happening in other jurisdictions and how it is being decided. So, this has been a major thing. Very interestingly, Government of India itself has rolled out a paper how to sort out. On one end, we need technology. We are not going to say no to high-tech providers. On the other hand, how the game is being played, whether is it reasonable, whether that incentive, an incentive cannot be something which overruns everything. Having said this, as I said, the CMII, which I said, Computer Manufacturing Association of India, Telecom Equipments Manufacturing Association of India, they have put up a paper. So, I am more talking from their point, then I come to from academic analysis in few minutes. So, what they say is a big paper condensed into 10 points. Demonstration of protection and advancement of national interest. This is one important point. When I say national interest, as I said, is IPR a global philosophy? The answer is no. Different points of history, different countries have tailored their policy. Like copyright was not at all there in United States for a long time in the way what they are talking now. Charles Dickens goes to United States, comes and cries the way these fellows are, stealing my work. Japanese were telling, oh, sorry, we could not translate the word copyright into Japanese. We have a problem with our language, right, for a long time. So, after you become stabilized, when Hollywood became the big thing, copyright becomes. When IT became a big thing in America, then copyright, assumes importance. So, it is like they call the crowded train syndrome, right? When you try to enter a crowded train, nobody will allow you. Somehow you get inside, then you block, don't allow others, right? So, this will happen a pecking order in countries many times. So, India is not still in that stage, probably India will have a different policy altogether. Now, they are talking, crying, telling that, see, look, national interest, affordable things, how is it possible? Is it a kind of royalty going out? Every royalty goes out, you don't need to manufacture. I get billions in terms of licensing thing. So, how do you do this? So, competition. So, one point of checking IPR is accepted, IPR is accepted, but abuse of IPR, abuse of your monopoly is not accepted under competition law. So, European policies are very effective on that. That is why majors like Microsoft or Google had a troubled times in Europe, because they were very effectively using competition policy as a checkmate towards IPR. Similarly, patented component, which patented component, why are you charging a royalty for the entire product? And then role of standard setting. These SSOs have nothing to do with patents. SSOs are technical organizations, right? There are few like International Telecommunication Union, you have IIEEE, few are there. They have no understanding of this complexity. But what happens quite often, SSOs are give certain standards and they say these are all standard essential patents. They have no data, sometimes they have no understanding, but they are brought in one sense as a support thing. And then ETSI, that is the European Technical Standard Initiative, It again takes care of Europe and its interest, but that is often touted as a kind of a global standard institution. And then high patent infringement cost. I need not tell you about the infringement cost. I have a few slides which I may not be going through, but you can go through later. It's very, very expensive. Very interestingly, if you look at it, the case is filed, 99% is settled out of court. Right? 99% is out of court. You may consider what peaceful, nice people they are settling. No. The person who settles as doesn't have deep pocket. So, for him, settling is a better way than running the litigation. Do you get my point? As often they say, the only guarantee in a legal system is the fees of the lawyer. Remaining are all what you call as great uncertainties. So, given this situation, so probably it is not that even universities, if they get a legal notice, they are not going to run behind a lawyer, they will see how to settle this matter. So, eminent domain, this is another point. America often uses this called a concept in international law called eminent domain. In military, many things they say public interest, and then that is eminent domain. That's what US uses. Why not the same thing with others? China is using, without shouting on rooftop, China is day in and day out using this. And somewhere India seems to be still not coming out of their mind, still thinking that we are a country which is still servicing. We still don't understand that if somebody doesn't want India, when Novartis case came, the first thing what CEO of Novartis said was, hey, we will shift all operations from India. We are shutting down. Now the question, where will you go? If you shut down, where will you go? To China? Go to China? You will not even know what's happening on many front, right? So, Novartis did nothing. They are operating here and they are now expanding. So, this many a times what you call these type of threats, probably India still doesn't understand, still is not realizing the kind of market potential and the way you can bring certain negotiations to the table. So, that is important. And then as I said, the declarations of the patent holders have fared very badly in courts. Many a times it is fair. Even in Indian courts, many of them have been struck down, and global decisions on IP will have impact on India. This is one way of trying to give you a macro picture, and this is where the whole topic given to me is revolving at this stage, because it's still rudimentary about electronics and telecom. It's very complex for us. In these few years, you have seen that you had very distinct thing called telephone, a very distinct thing called computer. Am I right? Now you have a mobile where it's all, your world is that. Your world is your mobile and everything is done. So, what type of invention, what type of protection, what type of pricing requires a great understanding of regulatory understanding, economic understanding what's happening, and also what I call transactional licensing, contracts, other things which are needed. So, if I given you the overall brief, now I will quickly go in another 10 minutes or so, right. I gave you this in, what is that, 80 million worldwide patent documents, 2 million worldwide standard documents are there on these areas, 300,000 declared standard essential patent. Tell me which court in any reasonable manner can sit and finalize all this. 450,000 patents referencing standard as prior art, 15,000 patents that are subject to patent pools, and 42,000 patents are subject in US litigation. You can see the number and final litigation part. Most of the things doesn't get into litigation. That doesn't mean it's peacefully and fairly solved. It's always solved because somebody is powerful and big, and many are what you call as have to sign the dotted line, because the economics of law is not easy. So, when economics of law is a big threat to you, you do what you call as, okay, give away your, even what you consider legitimate. So, who should step in? Only option to step in is government. Only option for the state to step in if state is looking after what you call national interest as its priority. So, I am quickly telling, this is the case in Ericsson against Micromax and again versus Xiaomi. In High Court, in both cases, passed actually on a similar principle of micro case, talked about a kind of a interim thing. Interestingly, morning Justice Bhat was telling how he gave an order and then later on realized the impact. But one doesn't fail to understand in India why interim injunctions are given, because books are there, many things are there. It is going to come. By giving an interim injunction, you are actually forcing the players, the smaller players, which could have won at a later stage, have to completely change their business model, because they are working on $50 margin and $75 margin or $100 margin, what they are doing. And whereas I look at the other side, very interesting. I don't know why we don't take American example when it comes to asserting ourselves. That is the best part we are missing. In Cornell University, HP was asking royalty on entire product, even though they had a patent for a small part. Who the party involved? An university. Interestingly, we are tied up with Cornell. Right? So, the court gives detailed judgment and arguments. They said entire market value could not be applied, and they said hypothetical processor revenue was appropriate for royalty base and included quantifiable amount in verdict that could be stricken for the remitter. The remittitor means the process by which a court compels a plaintiff to choose between reduction of an excessive verdict or you come for a new trial. This is what, and this was given by our Rajiv Gandhi school friend Randall Radar. It is his verdict. So, Radar is considered to be in certain circles very conservative and pro-patent, right? Even when Radar gives this much concession, am I right? And we should give more in terms of understanding how to give a verdict on this. Similarly, IP innovation versus Red Hat, a similar case, I am not getting into the details. The original case was that they were asking for the total sales of the entire thing what you are doing. Because they had a patent somewhere and that they said that royalty should be there. They said you need to really what you call as pierce, they use the word in law, piercing the corporate wheel. It's time you pierce the patent wheel. Find out where exactly and what you are doing and whether you are legitimate. Otherwise, it is called runaway patents. So, Unilock versus Microsoft, a similar case. For want of time, and because most of you are, then I realized non-lawyers, I didn't want to get into this part of the story, but you can always go and refer. So, eminent domain, which I told you, this what US does. This is simply means allowing the state to subordinate private property right to the public interest in certain circumstances, right, must be given some space, right. It is a well established principle in US jurisprudence, and somehow, the courts here have to look, or legislations have to also look at that if it warrants, of putting certain things into public interest. Having said this, as I said, the basics, as I said, is what you call as, many of you morning he explained, so I don't want to go into the what you call as the theory part. End of the day, I am telling you, all this are supporting one thing: public interest is a cornerstone, right? Because of public interest, IP came. It is not because of IP public interest is created. It is very clear. It is not chicken out of egg or egg out of chicken. It's very clearly, this egg is out of the chicken. As simple as that. Public interest and everything is what the theoretically they say, but we are far removed from theories, and we are in a GDP business, we are in international trade agreement business. There is quite a lot of arm twisting which happens, which policy makers on contingency are accepting, and that needs to be analyzed, and that needs to be a kind of a saner voice from academics and other people, even to identify to government what options they have and what else they can do on that. So, as I said, incentive and access. Now, the IP is not simply equated to profit. IP is used as a tool now called development, because we all need telephones, we all need many technologies. So, how do I put this? So, what is compulsory license is one way, in my opinion. The threat of compulsory license will bring in certain order in terms of telecom and other things. I have given you what is defining a compulsory license. In case of non-working of a patented invention, if wide use of a patent invention necessary for the public interest, if an invention of improvement requires the use of a basic invention. These are all very clearly written in the statute book, not just in India, across the world in many jurisdictions. For example, this is their part of the international law. In Paris Convention, they say the word, not compulsory license per se, they say prevent the abuses which might result for the exclusive rights conferred by the patent, for example, failure to work. Here it is not failure to work, blocking the work in terms of high royalty and other stuff. So, naturally I can bring a correlation that even it has been part of this. And then, as I said, in TRIPS, look at the TRIPS policy very recently. Protection against practices that adversely affect the international transfer of technology. So, see, when I sell, we are international, but when conditions when I come, we are not international, right? We will have different ways of doing it, different pricing we will do, and then we will tell my fundamental IP right is affected. So, you cannot have the cake and eat it too, right? So, it really requires a policy analysis, especially in a quietly engulfing area like telecom, and I am so glad that you people took up this issue. I am sure that if it is a curtain raiser, you will have further reports. This will open up more research reports for you. At least I am talking to the law school colleagues. More articles could come on this basis, how to analyze and what to do on this. And as I said, TRIPS mandate, these are all the TRIPS mandate. Authorization on merits, purpose of what is initially authorized, non-exclusive, non-assignable, power to review, adequate remuneration is accepted, not more than adequate, judicial review, against anti-competitive practice, to enable working of the second patent. All this makes it a very ripe candidate. So, having said this, as I said in Doha, we have made it very clear, and this is just for a list of compulsory license for you in Canada, in United States. Suddenly India gave one compulsory license in the entire history of 65 years, 70 years, and we became the villain everywhere. Everybody said, hey, you gave compulsory license. Which world you are in? The point is, this is going on for years in other places when it was convenient. You may not have now need for compulsory license. Somebody else has a need for compulsory license. These are all kind of a list I have given you. So, India is well within the international law TRIPS for award of CL, and we have a very reasonable and well tried judicial review for in 3-tier structure, and more than that you have got TRIPS dispute settlement body if you think there is a failure from Indian judiciary side. So, what is the problem I often used to analyze? I call this as qualia, that is what still now I am wondering. The same thing two people see differently, right? For someone this is the color, for someone this is the color. This is how sometimes I find IP also, that how do we can both see the same color? That is the big question in cognitive way of looking at things, and that is possible if you are going back to the basics, drumming on how these theories were built, drumming again and again how these theories are audited, whether it is serving. This is the crucial part. As I said, current problem is this, right? I am not talking peace. This could be another way of settling, right? And I am sure all of you would love to be here than here, right? You will not love to be on both sides, that I know, but you do not have a choice to box or to be in street fight. We will prefer boxing because every 3 minutes you can go back to your corner, a doctor can attend to you, right? You get my point. Coach can come and tell you, and if you are totally fallen flat, you are not killed. Somebody will rescue you, and then remember, loser gets half the money of the winner, not in street fight. So, this is what I want to tell. Compulsory license, often they say it's the danger. It's not the danger, it is the fire extinguisher. And how many times we have fire? We don't have, but we need the fire extinguisher, working fire extinguisher. That's a problem in India and most places. You see that fire extinguisher, but it will not work. The point is, we need to use it when there is a fire. Thank you.
Thank you, sir. Thank you. Thank you. Thank you, Professor Vivekanandan, for your illustrative and illuminating dissection of policy matters and sharing issues which might arise from that policy dissection. We have got another presenter or a person who is going to talk. We have a very young, vibrant lawyer amongst us. His name is Vineet Rohilla. He is a partner in Remfry and Sagar, New Delhi. He holds a master's degree in physics from Kurukshetra University, LLB from Delhi University. He has been practicing in IP matters in the last 14 years, and he has presented IP matters in almost all the high courts, tribunals, including IPAB. Most of the times he consults his clients on patent matters like the due diligence, portfolio, development and infringement of IP matters, validity, etc., etc. And he was part of very famous case Novartis. So here we have young, vibrant lawyer. I call upon him to give his presentation. Thank you.
Thank you, Professor Ubete, and good afternoon, everyone. I will give you an overview of patent practice before the Indian Patent Office, and especially in relation to the electronics and telecommunication side. Before starting, can I know who all of you have filed patent till now? Any one of you? Okay, but I believe you all are. There are few hands, and I believe all of you are inventor, or there is some inventor in every one of us, and so I will basically deal with how we can draft our patent specifications. This is my presentation plan. So there will be drafting strategy, how we can draft the patent specification. Sorry. I won't go into the nitty-gritty of the drafting as such, but I will advise you about certain do's and don'ts, so that there are minimum objections from the patent office, or at least we have a bandwidth so that we can successfully rebut the objections of the patent office and our patents are granted, specifically in cases of electronics and software. And I will touch upon patentability and the CRI guidelines, the computer related invention guidelines, which is issued by the patent office, so that the examiners can adopt the procedure for examination of these applications. And there have been different iterations of guidelines, so I will touch upon those, and certainly upon the practice and case laws, and there are a few case studies as well in the end. So drafting, before drafting any specification, you as an inventor have invented something, and after inventing, first of all, the first step that you prepare a invention disclosure. So you disclose your invention in a paper, and you also make like it's an electronic side invention. So you will also create or prepare a flow chart of your process or block diagram of various apparatus which are interconnected, and interconnection between those. And certainly before getting into the drafting, you will have to see or conduct a prior art search. Justice Bhat talked about the prior arts. Prior arts are those arts which are publicly available. So you have to distinguish your invention from those prior arts. So based on those prior arts, you can go into the strategy of claim drafting, which I will cover later on. So a typical specification looks like this, like I have given the headings. First of all, you have a short title of the invention. So suppose you have invented a LED panel. So your title of the invention can be a LED panel, or a TV having a LED panel, and method of producing the same. And the next is the field of invention. Here you describe which field you are referring to. So you can generally say that it's in the field of television, and it belongs to the LED panel. Then the third thing is the background of the invention. In background of the invention, you have to describe the prior arts or the related patents which are there in this field, so that the technology, you can have a perspective of the invention. Like in case of LED TV or LED panel, you can start from CRT technology. So there was CRT tube earlier, and there was big, huge TVs. Then came the LCD TVs, which were slim, but they were bulky, and they were using liquid crystals. And then the technology further developed. It gave rise to LEDs, and there is further development, like we have OLED, organic LED, which are like more lighter, more flexible. So we can give background in this perspective, and certainly then it's a requirement of the act that you give specific reference of the prior patents. So you have to give, it may not be patent, it can be any technical specification or technical paper which is there in the public domain. So in your background, you have to give all those details. Now comes the summary of invention. This summary of invention is most critical part. It basically set forth the novel and distinguishing features, like you have invented something, and it's novel and inventive, then you have to describe in your summary of invention that this is my invention. So it highlights the aspects of your invention, and there are various ways in which you can draft this portion. Like in the background art, you are describing the prior art. So you can give what are the disadvantages of those prior art, or what are the problem associated with those prior art. So in summary, you can say the object of my invention is to overcome those difficulties, those problems which were associated in the prior arts. Or the other format can be in the problem solution approach. So if you're filing an EP or a European Patent Office, then it's a requirement, then you have to draft this portion as a problem solution approach. So you have to identify the problem in the prior art, and then you have to give the solution. The next is the brief description of drawings. So you are giving drawings, and you have to give, like you have prepared your block diagrams, you have prepared your flow chart. So you can describe those, like figure 1 is a block diagram illustrating so and so. Figure 2 is a block diagram illustrating exemplary hardware configuration, and there may be flow chart. So some figures may refer to the flow chart. I will also show you examples of these diagrams and flow chart. Then comes the detailed description of drawings. This is the main or critical part of your complete specification. Here you have to write down the complete specification in detail. So like in electronics and computer related inventions, most of the times it's written with reference to the drawings. So like if you are given a block diagram, then you have to give block diagram in detail, and each and every block which you are mentioned in your diagram should be explained. And what are the interconnection between those? That has to be explained in this detailed description. Then come the describe the each block and functionality of flow chart. Like you are given a flow chart of your process which you are going to patent, or you are going to file an application, or which you are drafting. Then you have to give details of those blocks and the functionality, how these process is flowing. I will show you this example block diagrams. So like this is a typical block diagram where you are synchronizing your speaker with television set. So here the television set is connected with server and controller through a network, but this is very basic diagram. It won't get you to have a patent, or you won't be able to obtain patent. Like if your invention is in controller 11, which is described here, then you have to give details of this controller. Like in next diagram, this is a controller. It has CPU, memory, GDP, the graphic display processor, codec, coding, encoding, etc. So, and these are connected. So you have to show or describe each of the components and how they are interconnected, and how this is functioning, or how you are achieving your object of the invention. It has to be explained in the description. Similarly, this is a example of flow chart. Like you are synchronizing your the server, television set, amplifier, and speaker with controller. So this is the flow chart. Like you describe or you choose some content to be synchronized. Then the further step will be, it will transfer request for acquisition. Then it will transfer content list and will receive content list, and at the end it will acquire the synchronization operation. So these are the steps which will be carried out, like by controller, server, television set, or amplifier. So this is the flow chart you have to give, and you have to give the functionality of each of these. If I come back to the earlier slide, then you have described your block diagram, you have described your flow chart. Now the other thing is you have to describe other alternatives. It's not essential. It may not be sufficient that you describe only one embodiment. There may be several embodiments. You can perform your invention in different ways. So all those should be described in your specification, so that you have wide coverage in your patent. And this is a requirement of the Act, that you give best method of implementing the invention in your specification. But never restrict your complete specification to the best method, but give other alternative methods of performing the invention. And for the things which you have illustrated in figures, like you should use the reference numerals, like for controller 11 reference number was used, for synchronizing step S108 was used. And the most important thing which is written at the bottom is you should always give the examples and the test results which you have incorporated in your specification. It's very essential, because once you are before the patent office, and sometime like for electronics or software related invention, it's when the examiner is examining it, it looks like it's a very abstract idea. It's not implementable. So if you have sufficient examples in your specification, then it can overcome those objections, that it's not an abstract, but it actually providing a tangible product or tangible process. And similarly, you should provide test results if you have invented a speaker, and you have conducted some test that it reduces the outside noise or the surrounding noise, and if you are implementing some test, you have tested it in some laboratories or standard tests are applied, then that should be incorporated in the specification. Now I will come to the drafting strategy of claims. Now each claim begins with a preamble, and there is a transition term which says comprising, including, consisting. Like I've given example below, like if you have invented a portable speaker, then you can say portable speaker comprising. And this comprising and including are generally called as open-ended terms. So if you are using these terms, then this means there may be other elements as well which you may not have incorporated in your claim, but there may be some other element. But the other word, which is consisting, if you use consisting, then it means then you are limiting your claims to only those elements which you have mentioned in the claims. So like consisting we rarely use in electronic side, and certainly in case of some chemical, or if you are preparing some composition, you invented some composition, then consisting may be used. Otherwise, normally we use comprising and including in the claims. The second point is say as little as possible in preamble, otherwise it will constitute a limitation. Like I've given an example of portable speaker, like your portable speaker may be a wired speaker or maybe a wireless speaker, but if you include a term wireless, then your claims are restricted to wireless speaker, then it will not include the wired speaker in this. And if you further narrow it down and say Bluetooth wireless speaker, then it will be limited only to the Bluetooth wireless speaker, the portable speaker which works on Bluetooth. So it's very important, it's very critical that you know what you are claiming, and you should try to encompass thinking not only of right now what you are inventing, but the broader picture. Like I will give you an example. I was prosecuting one application in 2005, I believe. So do you remember that there used to be, before the mobile phones, there used to be one device which is called pager. So it was used for receiving and transmitting messages. So the specification was drafted more or less for pager, but by the time I was prosecuting it before the patent office, the technology was so advanced, and the mobile came into place, and the technology of pager was totally obsolete. So I was before the controller, before the patent office, and my client suggested, can it happen that instead of the pager term in the claims, we change it to the mobile communication device. So although there was few paragraphs, few references were there which stated that it's a mobile communication device is being implemented. But when we argued before the patent office, they said no, we won't allow the mobile communication device, because your specification as such is referring to pager, and your claims were earlier referring to the pager. So if you are changing it to mobile communication device, and it will broaden the scope which you already claimed. So that's not permissible under the Act. So we have to restrict our patent to a pager. And that's the thing. If you have initially thought of this, and instead of using pager, you would have used a mobile communication device, then it would have got some broader protection. Now, each element in claim is introduced by an indefinite article. If you are drafting a claim and you are using any term for the first time, then basically we use with term a or an, a controller or an amplifier. And if you are referring to the same term again in the claims, then we use the word the controller or the set controller or the controller. So, the primary, you would be aware the main claim or the independent claims are the most crucial claims. So, they can be in the form of an apparatus, a method or a system, and the apparatus, the main claim should encompass your invention as such. You should include all the features which are essential as well as novel in your main claim, and your main claim should be a self-sufficient claim. You should be able to perform, if this is an apparatus, then it should be self-sufficient that this can be identified, and this is a process, then it is itself sufficient that it's perform the whole process. And this is the example of claim where we distinguish like a portable speaker comprising element A, element B, element C, and wherein. So, this is called two-part format. Two-part format means there is one part which is already existing in the prior art, and the other part which we call normally characterized in that part or characterized portion of the claim. That portion is actually your novel or where your invention lies. So, element A, B or C may be available in the prior art, but element D is where your invention lies. And the next is each element and step should be clearly supported. If you have drafted some claim, but the elements are not present in the specification, then we are in big trouble, because patents are quid pro quo, means you get a patent because of your disclosure. If you are disclosing the invention, only then you are getting a patent. So, your specifications should be sufficiently descriptive of your invention, and it should be with the help of drawings and flowchart, and you have to use your reference numerals. And this is like a wide functional claim language, means for, if you are using like means for controlling something, instead of using this terminology, you can use controller. And if there is no collective term, then you can invent your own terminology, because every inventor or every patent drafter is a lexicographer in himself. So, you can invent your technology, but it should not be opposite to what is available in the normal nomenclature. Now, this is most important slides. You should always remember what is the purpose of your claim. So, claims is the main thing which define the scope of the invention and meets and bounds of your legal protection. Justice Bhat in the morning talked about the property and trespassing in the property. So, this is like patent is certainly an intangible right, but if you have been granted a claim and someone copies it or trespasses into your boundary, then certainly they are infringing your invention, and you can file a suit for infringement against that. And one thing you should keep in mind, it's the claim which is being infringed. If you have described something in the body, in the description, then that's not protectable. So, whatever is your invention, whatever is you have invented, it should come out in the claim. And in fact, several times clients or many people approach us and they ask us that some companies copying their product or their patent, and when we analyze it, and then we say, no, sorry, it's not infringing your claim. Then the person would be saying, no, it's just described in my description. It's okay, it may be described in description, but unless you have claimed it, you cannot file a suit for infringement against said infringer. So, that must be claimed, and only then you can institute a suit for infringement. And the next point is on the claims is, claims must not be too broad to embrace more than what you have invented. If you have invented this much, then it should describe this much. If you broaden your claim and encompass into it some prior art related things, then it will become difficult to enforce such patent, as well as they are easily invalidated, because few things are already there in the prior art. And similarly, it may not be too narrow, because if you are drafted too narrow a claim, then any person can design around those claim and work the invention, what may be the actually your idea and not his idea. And such narrow claims are certainly ineffective in any infringement related litigation. And the purpose of dependent claim you have defined your main claim, you have defined elements. So you can describe the interconnection or the embodiments, or you can further define the elements in the subordinate claim. So, and sometimes it is strategically we use as a backup claim, so that if there is prior art which can invalidate our main claim, so that we can cover up by introducing those features in the main claim. Now, the patent eligibility in electronics and CRI related invention, like most important is 3K, which I will be talking in detail. The other is 3L, which talks about literary, dramatical, musical and artistic work, which is primarily covered by the copyright. And 3M, mere scheme or rule or method of performing mental act. Like I can't patent my idea of my presentation, like I'm giving you a lecture, so I can't patent that's mental act and method of playing game. I may be Vishwanathan, maybe a champion of chess, but he can't patent the method of playing chess. Similarly, method of presentation of information as such can't be patented. And 3O is topography of integrated circuits. So there is separate act for semiconductor layout design, under which the topography of integrated circuit can be protected. So main section which is relating to patentability in this sector is 3K, which says a mathematical or a business method or a computer program per se or an algorithm is not patentable. So I will deal with each of these in my later slides. But before that, let me give you a perspective of evolution, how it came into the picture. So in 1999, 3K was introduced in the act. Basically, it was passed in a Patents Amendment Bill, and this bill was referred to JPC, or Joint Parliamentary Committee. So this was referred to JPC, and JPC worked on it, and they presented their report in Lok Sabha in 2001. And what you see today, computer program per se. So it was not there originally. It was on recommendation of JPC. The per se was introduced in this section. The primary purpose of per se was that computer program as such were not patentable. Very clear. But there may be certain cases, certain inventions which are ancillary to the computer program, which may not be actually computer program, but which are working or using the computer program to achieve some other objectives, and ancillary thereto and developed thereon may be protected. And there was one more attempt to amend this section 3K, and Patent Amendment Ordinance was passed in 2004, and it says a computer program per se other than technical application to industry or combination with hardware. So it tried to achieve the same thing by introducing in the act, but the ordinance lapsed, and it never came into the act. Now I will discuss the CRI guidelines. So, and the Patent Office has been shifting its stand on the guidelines. In 2013, they issued draft guidelines, and they defined various terms like computer programs, software, firmware, and various other like algorithm. And they gave the idea how the computer related invention can be patented. So major crux of these guidelines was if any computer related invention is performed with the help of a hardware, and which the hardware interconnectivity is more than a normal purpose hardware or normal computer, then it is patentable. But after there were various discussion with the stakeholders, and in 2015 the CRI guidelines were passed, were issued by the Patent Office. So these guidelines were very detailed, and they give all the they give nomenclature of everything, and they defined every, like algorithm was defined, software was defined, computer program, and they give a guidelines for the examiner that how they have to examine the application related to CRI, and it very clearly pointed out that if the novelty is in hardware, like if you have a novel hardware, then it is patentable. If you are claiming a novel hardware along with novel program, then it will be a patentable subject. And even if you are claiming a novel program which is running on a known hardware, and the interaction between them is such that the hardware goes beyond its physical capabilities and performs some technical achievement is there, then it may be patented. But these guidelines, 2015 guidelines, were challenged by various civil society organizations. In fact, they filed their representation to Prime Minister Office (PMO), and thereafter the 2015 guidelines were put in abeyance. And in 2016, government revised the guidelines, and they included very onerous requirement of novel hardware. So you can patent your computer program provided it's there with a novel hardware. So in today's, every software engineer will know it's very difficult. It's rarely the case that the hardware would be novel, because software engineers basically work on the programming side, and it's not, there may be some technical inputs and outputs, but novel hardware as such, every time you are inventing a new thing and you have to put novel hardware, so this was very onerous requirement. So finally, there were many representations against the guidelines. In fact, many of the applications were rejected on the basis of that this doesn't meet or your invention doesn't meet criteria of novel hardware. So in 2017, I think in June 2017, the Patent Office issued the guidelines, which I feel is balanced, and it omits the requirement of incorporating novel hardware, and an examiner has to ascertain the nature of computer-related invention, where there is a technical advancement as compared to the existing knowledge, or have economic significance. It has to focus on the underlying substance of the invention, irrespective of the forms. Whatever may be the forms of claims, the controller, or the examiner, or the patent office has to see the underlying substance. If underlying substance is a computer program, in whatever way you might have claimed, it may not be patentable. And the guidelines also say that means plus function are allowable only if structural features are given. So if you have structural features, you have given diagrams, and you can refer the structural features with those means, then the same can be allowable in claims. Now comes to the practice. Now I will discuss each and every exclusion which is there in section 3K, like mathematical method. If it's an abstract mathematical method, if you are claiming mathematical calculation, formulation of equation, theorem, mathematical based on the same without practical application, then same is not patentable. However, if you are patenting, I will give you an example, like if you are patenting a reactor, and in this reactor you are using mathematical equation for measuring some temperature or pressure, and you are claiming a reactor only where the mathematical equation are used for measuring few parameters, then the same will be allowed. The same is generally allowed by the patent office. Similarly, business method, online money transaction, method of bookkeeping, method of lottery, ATM transaction, method of carrying out business, trading, financial activity. So these are not allowable under the business method exclusion. Like if after demonetization, the Paytm app or Paytm became very successful, and if they wanted to if Paytm wanted to patent their method of transaction, then that was not allowable, because it's primarily a business method. So there is only one case law in India, which is Yahoo Incorporation versus Rediff, which was decided by the IPAB, and it says if in substance the claims are relating to business method, even with the help of technology. Like sometimes cleverly what we do, we incorporate technical terms, like we use, we incorporate some hardware features, internet, network, satellite, telecommunication in the method claims. Then the IPAB held, even with the help of those technology, essentially if they're claiming a business method, even then the same is not allowable. However, if you are claiming a method, instead of a method, you are claiming any particular device or system which incorporates all these features, then the same is patentable under now algorithm are like a set of rules or instructions that enable some operation to be performed. So whether employing logical, mathematical, or computational. So algorithm is basically applicable in case of computer related information. So algorithm as such is not patentable. There is one case law, I will discuss it later with respect to the algorithm. And computer program per se. If you are so computer program as such, if you want to protect the computer program, then same is not patentable. It may be a set of instruction or computer program, like if you have few instruction which is stored on a readable medium or a CD, then same is considered as computer program per se, and the same is not granted patents. And what's the practice in patent office? If you are claiming a device or a system claim, and there is some novel component within the device, and you have a software as well, but the novel component is doing a primary role of processing the software, then the same is certainly allowable by the patent office, and in fact readily allowable by the patent office. However, the most critical one, or the most rejection which we receive, is in the method claims. And what we do for the method claims is to be patentable, the method claim should provide hardware implementation, or should indicate hardware implementation, and should also exhibit a technical effect. So if there is a technical effect, and as well as there is hardware implementation, then the same is allowed by the patent office. So most of the patent attorneys who are dealing with the software related applications, they always emphasize on technical effect versus mere software before the patent examiner, before getting their patents granted. There are two case laws. There are not many case laws in this field, but two case laws which are very recent in time and decided by Delhi High Court. So in this Ericsson versus Intex, while examining Section 3K, the Delhi High Court has ruled that if the invention has a technical contribution or has a technical effect, and then it's not a mere computer program, then it's a patentable subject matter. The second one is Ericsson versus Lawa. So in this case, there was no case law. In fact, all over on algorithm, because algorithms are somewhere not mentioned as such as, but in India it's specifically mentioned as exclusion. So in this, the court observed that the bar of Section 3K does not apply when a patent involving modern technology algorithm is employed in order to perform certain calculations or selections, which are thereafter utilized by various hardware components or elements to produce or improve a technology and create a practical effect and result in a physical realization. So if your algorithms are running in the background, and there is some other physical realization or some there is other improvement in the technology, then same is patentable. Like in Lawa case, it was the argument that these algorithms are run and they are just the source code, and there is nothing, no improvement is there, but code held it otherwise. So lastly, I will show you two case studies. This is like a main claim or the primary claims of this patent which was recently granted. So in this, what's happening is it's an invention where there is peer-to-peer communication between devices. So, like there are multiple devices, like we have mobile phones. These devices are communicating with each other without connecting to the central server or without connecting to the base station, and they are communicating and using resources. This was the invention. So, the point which I was emphasizing, you will see in next slide. So, the underlying part is the part of claim which we has to introduce in the claim, so that we overcome the section 3K rejection. Like they are storing, transmitting, monitoring. These steps were identified from the flowcharts which I discussed earlier, and there were hardware implementation. Like if you see various storage means, transmitter means, control means, so these all were hardware features. So we incorporated this hardware means in the claim, as well as we identified the reference number for various steps, and certainly there was a technical effect in the sense that it was using the resources in an optimum manner, and it was not relying on the central processor or the base station for implementing this invention. So this patent was granted, and there is one more. This patent was rejected. So the software developers usually use this is called API testing. API is application programming interface. So like developers keep on developing things, and they are stored in their repository. If they require any specific application or a specific function, then they have to search, and their specific search results which are obtained are sometimes tedious to obtain. At the same time, it may not result into the desired functionality. Like you are designing a specific functionality from an application, but the software may not give that functionality. So this was an invention where this overcome this drawback, and it gave an effective search strategy, so that software developers can easily search and the desired functionality can be obtained. So certainly there was technical effect in this, and in fact the patent office of the controller, while refusing, admitted that there is a technical effect in this invention, and you see there is mention of processor, memory, and these hardware features are also incorporated in the specification in the claim. And the other point is like the technical effect was there, hardware limitation was there, but still the patent office rejected on the basis that the underlying substance of the invention is software. It's a pure software which is being claimed, although the technical effect is there is hardware limitation, but still the software, so the patent office rejected this application. This may come up before the IPR. If some appeal is filed, then we have to see the fate of this application. But as of now, this has been rejected in the section 3K.
Yeah, Anka, please. My question is, you put greater emphasis on claims. Is it possible that two dependent claims together itself they constitute a main claim? Is it possible?
That will depend on the strategy and so on, what you are claiming. But the primary claim is the independent claim which should define your invention. So your invention, what you have invented, should be subsumed in the main claim. If it's there in the main claim, these dependent claims are basically for the purpose of elaborating the feature, or if there is some interconnection or there is some functionality, that can be defined in dependent claim. The main claim should be self-sufficient claim. It should define your invention independently.
So we should consider it as a separate.
You can have more than one independent claim in a specification, but like you were saying, you want to merge two dependent claim to make an independent claim, then that will like vary from subject to subject or independent invention.
Okay, this is subjective.
Well, you can discuss in person. I think
we can take one more question. Okay.
Sir, my question is to Prof. Vivekanandan, sir. So the discussion paper has been released by the SEP discussion paper. I think that at the end of the paper they were calling for some empirical findings, and that has been now carried out by Zidal Global Law School. So like what is the value of that, that DIPP policy? It has also the copyright case. The DIPP policy has violated some copyrights. They have not given some acknowledgements to the Europeans and US cases. So like what is the value of that policy? And second question will be, what is the role of SSO in India?
Oh.
SSO in India, standard setting authorizations.
Okay. My comment was, as I said, this is overtaking very fast, electronics and telecommunication. And more than patent issue itself, the way it is operated as transactional IP, what we call, of royalty, other issues, license, is become too complex. So when you said that, you said Jindal is doing that, all that at least we are trying to figure out what is the standard essential patent, how far is up you are claiming it's a standard essential patent, and the connection with the SSO, they don't have much in-depth understanding about what is a standard essential patent. You remember, they are more a technical standard setting organization. They are not into IP business. So, but often they are pulled as a backdrop and said SSO has accepted us. So, my question, even if you accept what is the standard essential patent, what are the correct parameters, or it should be dynamically changed or no, it's the same thing. These are all the questions. DIPP has put up a paper, keeping some policy view, but as you said, more empirical research has to come. Maybe when Jindal brings out, etc., you'll be able to make some conclusion on that.
How much I can rely on that?
Huh?
Maybe I'm doing research on everything. How much I can rely on this DIPP policy paper?
The paper, policy paper. What is reliance here? This is DIPP's interest.
Okay,
I told that some issues they raised. These are DFPP's, as Government of India, their position paper. The think tank, national IP policy, all that is the macro direction where they want the IP to go. There is no hard facts there. Whereas CMAI, they all have to bring, because they are business people. So they will bring that will be clear. Or any other academic research to do what is happening in different jurisdictions will be empirical. For us, DIPP, in the sense, it is a government, the current government, and its understanding and the direction of, to an extent, influenced by other associations. So you have to rely on policy document. That is, why a government has such a policy, the government believes in it.
Copyright complaints. Thank you, sir.
I would now request Professor Vibhute to hand over a memento to Mr. Rohilla. Now I will request Professor C.R. Raj to hand over a memento to Professor Vibhute.
Professor Vivekanandan, and thank you for the presentation.
They say, one's intangible assets may be greater than one may realize. With this, we now move on to the session 2, Intellectual Property and Quality of Life. I request Honorable Justice Ravindra Bhat to chair the session.
There are two speakers. Aniruddha Bose, who spoke to you very briefly in the morning in the inaugural session, and then the other speaker here is Professor Imtiaz Gulam Ahmed. One of the privileges of being a chairperson for a session is that you don't have to speak, you just to listen, and therefore I will exercise that privilege wholeheartedly. And before that, a brief word about the first speaker, Justice Bose. Honorable Justice Bose finished his higher secondary examination from St. Lawrence High School, Calcutta in 1976. He completed his BCom from St. Xavier's, Calcutta, and LLB from Surendranath Law College, and enrolled with the Bar Council of West Bengal as an advocate in October 1985. Justice Bose has practiced in the original side as well as the appellate side of the High Court in constitutional and civil matters, with special emphasis on intellectual property law. He became a permanent judge of the High Court at Calcutta in January 2004. A few words more personal in nature. I have known Justice Bose in my previous life as a lawyer. We happened to do some cases together relating to civil liberties. So, and of course, he has more experience as he practiced on the IPR side as a lawyer. In one sense, our career paths also have been kind of parallel. Of course, he became a judge earlier in 2004 January, whereas I became in July 2004. And it's been very a privilege knowing him. Last year we had intense interaction because we put together a book known as Courts of India, Past and Present, and I'm very happy to announce that Justice Bose was one of the prime contributors when it came to the Calcutta session. He and a colleague of his, at least according to us in the editorial, we felt that this was the gold standard that they had in writing. So, Justice Bose has got deep knowledge in the subject, and without further ado, I would invite him to come here and speak. Justice Bose.
I will start with a story which has nothing to do with intellectual property. See, to expose the ignorance of Mullah Nasiruddin, the Sultan sent him to a gathering like this. And so, Mullah Nasiruddin asked the audience, "Do you know what shall I speak about?" All said no. Mullah, there is no point in talking to you. You are wholly ignorant. Next day, the king didn't want to release him or relieve him. All of them, all the audience to the same question said, "Yes, we all know." Well, then also no point. All of you know. Third day, half of them said, "Yes, we know." Half said, "No, we don't." Well, very well. All those who know, kindly tell those who do not know. What am I going to speak? Now, you've heard previous speakers in depth speaking on intellectual property. So, very little to add. It's always a pleasure to come to IIT Kharagpur, and this time with Justice Bhat, an old friend with whom I have interacted a lot and still do, to speak about intellectual property, how it impacts our everyday life. Now, this impact is at two levels. One is contact with intellectual property. After we get up, when I want to use the toothpaste, if I don't get the familiar toothpaste, I feel disturbed. If I don't get the familiar newspaper, I get disturbed. If the familiar channel, TV channel is not there, one gets disturbed. Now, we are used to certain brands, and brands dominate our daily life. This is the first point of contact so far as intellectual property is concerned. Even scientific principles are branded. Newton's law of motion, Chandrasekhar limit, Bose-Einstein condensate. Okay, no one has trademarked them, but they are known by this kind of identity. So, that is a point of contact through which our purchasing decision, so far as items of consumption is concerned, purchasing decision is subtly influenced by, mostly by advertisement, which we fall for, all of us. You change the brand, same product, psychologically you will say, no, it's not proper. But that's not what is really impacting our daily life. There is a covert impact of IPR which you can recognize, but people, okay, in England they say man on the Clapham omnibus. So, maybe Kharagpur local he won't be able to identify intellectual property as the cause when the say prices of pharmaceutical products go up, or a new drug is hugely expensive. Out in the fields, farmers are worried today of the impact of plant breeders protection legislations. There is a bar on use of second generation seeds or the terminator technology itself. So, intellectual property regime is enclosing in a way public space in the virtual or real world more than ever in the past. For a long time we had practically free access to entertainment through the public broadcast system. We used to pay a license fee for the radio once a year. Later on that was also abolished. We do not know what was the arrangement between the producer of the songs and the AR All India Radio, but we did not have to pay for that. We took it granted that the cricket match at Firoz Shah Kotla or Eden Gardens would be telecast, and suddenly I discovered one day that I could not see the World Cup because I did not have a particular TV channel. I did not have access to a particular TV channel, and then that was I had to pay additional charges to my cable man. That time the dish TV had not come. So, certainly we are finding what was in public domain, it in a way remains a public property, because the cricket match is going through public space to your home, but this space, the transmission space, is being commoditized and sold out. So, what was in commons in real terms, real world we use this term commons. This entire Magna Carta was built on a fight over commons. That is being enclosed through intellectual property law. Now, I am not making a value judgment on its good or bad. Sports persons are getting much better rewarded. Singers, artists are getting better rewarded than before. I think to be a artist worth it, 40 years back one had to die out of tuberculosis at the age of 50. Then only you were rated a good artist. Now at the age of 30 you can have 5 BMWs in your car parking area in the home. History has indirectly a lot of instances where intellectual property was protected, though the term did not come into existence. Using the technology of fire, which was made into a myth that he was trying to steal fire from Jupiter and for which he was punished. All of you have heard of the story of Ecolo, who was not permitted to enter into the training arena of Dronacharya and had to pay by amputating his right thumb. Then there were a lot of voluntary giving up also of intellectual property. The name which comes to my mind immediately is that of Jonas Salk. He chose not to patent the polio vaccine, saying that there is no patent, it is a public good. Then, okay, slightly out of fashion, but many of you still wear, I think, the t-shirts of Che Guevara. So that photograph was taken by a Cuban photographer, Alberto Carter. He died a couple of years back. He never claimed copyright on that photograph. So it became an iconic figure. Only once when I think vodka manufacturer or he used that iconic photograph for the product, he sued them, paid the damages to Cuban health system. But these are again individual initiative to not to claim title. A factor which to me is a kind of concern is an aggressive attempt by some concerns to appropriate matters which were or should have remained in public domain into private property. The song Happy Birthday to You, it got liberated last year. For 40-50 years, one entertainment company was taking a claim, and one estimate says that total realization of royalty was US $50 million out of that song. So $700 were charged for each use of that song in movies. It is not that only public domain is shrinking. Attempts are being made to appropriate private domain as well. Now I'll explain this. Whatever we are buying through the internet, that's my information or your information. Somebody is aggregating that, and your purchase habit becomes a private property of somebody else without your knowledge, and that is being commoditized and sold to a third party or fourth party. The rationale is that you are getting the service free, and this in exchange of that you give away your information. But that's at least what you do in that BRCA patent case. Gene of a particular person was sought to be patented by a company, which was actually isolated by them, I guess, through application of a known technology. Otherwise, that isolation process would have had to be patented. Possibly, Padmavati, is that correct? That isolation was in public domain, but not the gene. So, one's own property is being isolated, and somebody wants to claim ownership of that and charge money. Fortunately, whoever the claimant did not succeed in the US. The second area which I feel are of some thinking is required is essentially concerning us, the legal community. Now, just as Bhat spoke about it, private premises are being allowed to be searched by private litigant without making a party in the form of John Doe or Ashok Kumar orders, which was till now only in the power of the sovereign authority. Police could do the search, but not a private person. And the litigant is not being named in the court also. It's a suit against unnamed litigant. The plaintiff directs the commissioner to go and raid his premises. And through the civil process, the right to property is being encroached upon. Now there are decisions, I am not to comment on good or bad of it. Okay, emboldened by the fact that I am in an academic institution and So doubts can be raised here. Worrisome also are efforts to scuttle academic research on the ground of it could lead to IP violation. There was a Russian computer expert, 2001, Dmitry Skylarov. He was reading a research paper about some shortcoming in the security, e-book security system. He was arrested at the venue itself, that you are enabling others to infringe the copyright by exposing what was the shortcoming in the breach. Then through plea bargaining, the case against him was dropped. The trouble is, technology itself is making breaches of intellectual property very easy. Possibly Elon Musk only, he referred to internet as a billion Xerox machines on steroid. So that is the copying capacity of internet. With films and songs uploaded in the internet, I am never sure whether I have reached copyright or not. And when you see the movies on the internet, you are also exposing yourself, unless it's on a paid subscribe channel, exposing yourself to the midnight knock on the door. And it has happened in certain cases when a movie is launched on the first day itself. In Kerala, in one Malayali film, that 40-50 people were raided, and they were only watching the film. Now, why is it happening like this? If you go back to the history of history, source of every form of physical property is force. Somebody acquired some property by force, got rid of others through that property, and then got the system to recognize title of his ownership of that property. So physical properties have a linear feature that to trespass or take away, one loses out that property itself. It's no more with the original owner. But intellectual property is only replication. By replication, the property loses its value. But there is a two kind of graph. Initially, by replication, the value goes up. If you keep a creative work in your cupboard and it's of no value, then no one would read it. Art has to go up a bit in terms of popularity, and when it reaches certain level, then it acquires property value. So in the process, those who are reading it and telling others it's a good book or a good song, they are also contributing to the value addition. Now that is the argument which is used in Justice Bhat spoke about publicity right cases. One model, she was coming out of this Office of Alcoholic Anonymous, celebrated model. Nomic, I'm good. This newspapers, they published the photograph. Then she said it's a breach of my publicity right. Newspaper defense was that we are not photographing everyone coming out of Alcoholic Anonymous. You have yourself put yourself in public domain by cultivating image. Now you cannot control or manipulate your image in the way you want to show it to the public. If you are in a public place, then you expose yourself to kind of public photography. Now, intellectual property has actually generated some works of mind, and largely through judicial process. The core intellectual property comes from charter historically, but later developments have come through the judicial process. Of course, on patent you should have the Diamond Chakraborty, Diamond Deere, State Street Banking Corporation, which are taking the IP law ahead. Now, the problem arises, there is very little public debate on what would constitute protectable right and on price control. It gives monopoly as a reward for inventing step. The pharmaceutical companies, their defense is that it costs $2.6 billion to introduce a new pharmaceutical product. But the calculation on what basis, that's done in a very opaque process. There's a voluntary organization, Doctors Without Borders. They peg it to some 35 or 40 million dollars or something like that, a little ahead, a little beyond that. Then the owners of intellectual property want to control post-sale use of the property. If you buy any magazine for sale in India and Nepal only, that is treated as an implied contract. So you are, but even where it is not there, the principle of parallel import is being introduced to prevent a product being taken to a different jurisdiction. What is happening in reality is the concept of ownership we are losing, and all of us are becoming tenants of technology firms. In real terms, if you are a tenant of your own residential place, here you are a tenant of what you are using every day, tenant of technology. But I felt I own the software, actually it's a license, and it cannot be copied and distributed. It has to be worked out only in a given jurisdiction. So it's changing our concept of ownership. Modern times of acquisition, as some of the economists like Thomas Piketty is arguing, that everything is owned by few and the rest are all tenants. And intellectual property law is playing a big role in protecting that kind of society. Because ultimately the lawmakers' wisdom will decide, but there is very little public debate, except cases like GM food or Terminator technology, very little public discussion on intellectual property legislation. I don't recall a parliamentary debate ever any IP subject, except maybe this GM food, that too for health impact. Now, what are we to do? You are a very informed audience here, the students particularly. There is an intellectual pursuit is necessary to understand intellectual property jurisprudence. What is actually happening? Our known understanding of ownership or known understanding of property law cannot apply to intellectual property law. I personally would welcome you to think about it and come up with solutions, or at least raise the debate in public about the future path of intellectual property law. Thank you.
I would request the chair to hand over memento to Justice Bose.
Thank you.
Thank you, Justice Bose, for that very illuminating and perceptive talk. Now I will request Professor Imtiaz Gulam Ahmed to come here and deliver his lecture. He is a professor of law and head of the Department of Law, Sikkim University. Professor Ahmed specializes in areas of jurisprudence, corporate law, human rights, family law. He holds an MA, LLM and PhD degrees and is the author of many publications. Professor Ahmed, please come.
Chairperson of this session, Honorable Justice Bhat, Justice Bose, Professor Raj, Professor Goutam Saha, and of course Professor Vibhute, other dignitaries and of course participants. The topic which I have been assigned is human rights and intellectual property rights. Here I think I would like to first talk about human rights and then intellectual property, and then the interface between the two. Well, actually, we have been hearing right from the morning about the nature of intellectual property. In fact, I think we have made great advances in this field, and perhaps it is due to the advances that we have made in this field that we have got this quality of life today, the stage of our development, the stage of our well-being today, virtually in all respects, in every sphere of life. If we think about right from the mobile that we are using, the laptop that we are using, the sound system that we have here, when we go out, well, of course, we are virtually using all the amenities of today, which are in one way or the other, which are in fact intellectual property, and it is the intellectual property that actually that has transformed our entire quality of life. But then this quality of life that we are having, it has individualized property, it has actually capitalized property, and it has rather put the notion of property in a narrowest form, as we have been listening to various speakers. On the one hand, we have excellent quality of life, we have highest quality of life, we have attained the maximum, we have got all the comforts possible, we have got all the amenities possible. But on the other hand also, there is a huge section of society which is in a way deprived of all this, all the amenities that we have. In fact, they all belong to a small section of society. There is a huge section of the society, huge segment, where you find, where we all have seen, all these amenities are not accessible. In other words, this advancement in information technology, in intellectual property rights, it has, I think, polarized the society that we have. On the one hand, we have extremely accessible
segment where everything is accessible, where everything is available. On the other hand, where we have people who have entirely different kind of life, where hardly anything is accessible. Now, in other words, they have been suffering progressively perhaps due to this advancement in intellectual property regime. As the property has enhanced, as the property has increased its space, well, of course, the space for those people has been constantly shrinking. In other words, they have tremendously suffered in their basic rights. We have got some hints here, we have got actually some of the speakers touching these areas, that they have suffered because the public domain has been constantly shrinking for them. The human rights which they have been enjoying so far, the human rights which they had full access to, they have been constantly losing. They have constantly lost those rights. Now, of course, these human rights we say are those rights which are possessed, which are enjoyed by those who are simply human beings. These rights are available to human beings only because they are human beings. No other qualification is required for this purpose. No other requirement is there for possessing these rights. These are the rights which are available to everyone simply because he is a human being. Now, of course, a right in this sense is anything which a person is entitled to have when perhaps he was right from the days of state of nature. In the state of nature, when of course the state was not there, even at that time these rights existed, these rights were there. So, these rights simply human beings possess and enjoy only because they are human beings. Well, of course, Hobbes, Locke, Rousseau, they have talked about these rights, how they are inherent in human beings. And then of course, these rights actually some say are available to human beings because they are recognized by the law, and the law has to recognize these rights because the law respects human will, because human beings have will, and because law has to respect their will, the law permits them to have their will, and therefore, to the extent to which they have their will, the state should not interfere, the state should not go into that, and the will of the people will be prevailing, and there you will have the rights which are actually called human rights, because they are manifestation of their will, they are in recognition of their will. But of course, there are others who believe that rights are simply interests. A right is simply interest, like Salmon and others. They maintain that right is simply an interest which is recognized and which is protected by the law. Any interest which is recognized and which is protected is a right. And of course, if it is recognized and protected by law, then it is a legal right. If it is recognized or it is protected by our moral code, then it is a moral right. Although there are others who do not recognize these moral rights, they say moral rights we do not have, but without moral rights I think we will not be human beings, just as without moral obligations perhaps we will be something less than human beings. So, therefore, these rights which are recognized by the law, the duty is to respect them, and the violation of these rights would be a wrong. So, these rights exist for human beings in recognition of their interest, and when we recognize these interests, they are enforced by the law. Of course, even when the rights are recognized, even when the interests are recognized, always they may not be enforceable. For instance, sometimes we have problem in enforcing some debt which is time barred. The law may recognize such a debt, but the law is not willing to enforce. So, here in human affairs also we may have rights. They may be recognized by the law, they may be recognized by our moral code, but they may not be enforceable. But when they are not enforceable, it is not that they are not there. If you pay a time bar debt, the debt is paid. The person who pays the debt, he cannot go back and say, well, please give back to me the money, it was paid wrongly. The debt was there, and therefore, the payment which was made was in satisfaction of the debt, and therefore, the person who has paid cannot claim it back. In other words, these rights exist regardless of our enforceability. To a great extent here, in the case of human rights, that is the case. The rights are there, legal system may recognize, legal system sometime may not recognize. Mostly, of course, every civilized legal system recognizes these rights. In fact, in advanced legal system we find these basic rights, human rights, recognized in the fundamental law of the land, such as the Constitution. We have in part 3 a number of human rights which are enshrined, which are incorporated, and which are not only justiciable, but which are enforceable under the writ jurisdiction of the superior courts, Supreme Court and the High Court. So, they are expeditiously enforced because they are enshrined in the document, which is considered the most important document as far as the law of the land is concerned. But then there may be other rights which are in fact only legal rights, which are not under the Constitution, but which may be available under other laws, but they are nevertheless enforceable. Still there may be many other rights which are not under the law, which are actually not exactly under the law that we find, but which may be available under a contract. You may enter into a contract with someone and then you may acquire these rights, and again those rights will be enforceable. Now, here we may have actually most of the rights, I believe, recognized, which are human rights, which are recognized, which are contained in the laws of the land, Constitution and other laws, and therefore, which are enforceable. But then there are other rights which may not be available under these instruments, and still these rights are available, still these rights are enforceable. For instance, the Protection of Human Rights Act defines human rights as any right relating to life, liberty, equality or human dignity as contained in the Constitution or as contained in any other international covenant as enforced by the courts. So, even if some particular right which we consider human right, which is recognized as human right because it possesses one of these qualifications, even if it is not contained in the Constitution, even if it is not contained in any law, it can be still enforced by the courts if it is found in one of the international covenants, one of the international documents. In other words, here we have the universality of human rights. Human rights are all pervasive. Human rights are all pervasive not simply because they are there inherent in all human beings, but because they are recognized in our national legal system, they are recognized under the different segments of our national legal system, and also because they are there at the international system. And here if we look at our own law, we find that the international regime of human rights in a way is well integrated into our own legal system when we look at the provisions of the Human Rights Act. So, the regime of human rights is all pervasive, and of course rightly so, because it relates to human nature, it gives to human beings what they deserve only because they are human beings. On the other hand, we have intellectual property, well, where we have in fact a property perhaps of the highest kind because here the property is produced by human beings by using their best. The best part of human beings, of course, we consider brains, we consider intellect, and when a property is produced by this intellect, it is to be rewarded and therefore it is recognized. The product of human intellect is therefore intellectual property, as we call it, it is a property which human beings produce by using their highest ability, and therefore, they are to be rewarded. Therefore, their efforts will have to be recognized, and in this form we have intellectual property. But the problem with intellectual property is, I think, on the one hand, we have to reward the person who has produced it, we have to reward the person who has put in efforts, who has used his mind, his brain, his intellect, his money even, and his time. On the one hand, we have to recognize and reward him. On the other hand, also we have to take into account the interest of the society, the interest of the people, the rights of the people, human rights will have to be reconciled with the property that they have produced, the intellectual property. Now, here in fact, I think also we should pause a minute and look at this term property, because there was a time when the term property was used to mean anything that a human being had. Blackstone, in his commentary, he has used the term property to mean anything that a person could have. He says, I have a good heart, that is my property. I have good muscles, well, they are my property. I have good intellect, that is my property. I have property in my child, I have property in my servant. So, in that sense, property simply was used to mean anything which a person could have. All that he had was his property. Now, later the term property again has undergone a transformation, and then it came to mean simply all rights which were considered as proprietary rights, in contradistinction with personal rights. All proprietary rights, whether they were in rem or they were in personam, they were all considered as property, simply because they were proprietary rights. So, my land was my property, my building was my property, and my money in the bank was my property, the debt which is owed to me is a property. In that sense, again it came to be used, and then still in a narrower sense again it was used to mean only those rights which are proprietary, but which are only rem, which are not in personam. Personam rights were considered as obligations, and in fact there were other writers like Bentham who used the term property to mean only corporeal property, very different from incorporeal property. He said property so called should be considered only corporeal property and not incorporeal property. In other words, there was a time when this incorporeal property, what we call today as intellectual property, was not recognized as property. I mean, can we think of this situation, that there was a time when persons like Bentham, in his Principles of Morals and Legislation, he said property is property so called corporeal property and not incorporeal property. Now, of course, property perhaps in the best form, in the highest form, the most precious property that we have is intellectual property, although we all of us may not have. Of course, we are hearing about patents created, about copyrights being registered. So, this growth of intellectual property that we have today is of recent phenomenon comparatively compared to the institution of property. It is of recent phenomenon, it is a recent development, but at the same time I think today any economy is considered advanced, any economy is considered as rich only because of this intellectual property. But then when we have intellectual property, we need to reconcile this intellectual property with the human rights of human beings. Although they are different, there are two schools of thought in fact. Some say that they contradict each other. They contradict each other because they are not consistent with each other. They can't go together. But then there are others who say they can go together, they are consistent and they supplement each other. Human rights human beings have because they are born as human beings, and these rights are therefore considered universal. Whereas intellectual property we have with some who have created the property. Human beings get human rights because of their birth as human beings. Human beings get intellectual property because of their efforts, because of their creativity and because of their labor. But then after all, any property, every property should be used to serve human ends, to serve human beings, and therefore, there is a need for the state to regulate not only human rights, not only fulfillment and enjoyment of human rights, but also the regulation of the intellectual property, so that on the one hand those who create the property, those who are responsible for the creativity, they are benefited, at the same time those who are supposed to be the beneficiary, the society, the people, they are also benefited equitably, they also become sharers in the intellectual property. In other words, intellectual property and human rights should not be polarized. Issues of human rights and intellectual property should not become two poles. They must be integrated, and the integration can take place through the medium, through the regulation of the law made by the state. If they become supplementary to each other, if they become complementary to each other, they will serve human purpose. Otherwise, perhaps the cleavage between the rich and the poor will only increase in times to come. Therefore, I think we should try to harmonize the two regimes which are actually, I do not think they are two different regimes, but they are at least considered as two different regimes, the regime of human rights and the regime of intellectual property. They should be integrated, they should be harmonized through the medium of the law made by the state. The state has to regulate both. On the one hand, the state has to ensure the promotion and protection of human rights. On the other hand, the state has also to reward those who create this kind of property, but also has to ensure that the property so created is used for the benefit of one and all. Here perhaps that is why we have this kind of property. When it is created, it is given to the creator only for a particular period of time, not for all time to comes, as of course it is the case of in any other property. If you have a land where of course your children will have, your grandchildren will have, and it can go on and on. But when we have intellectual property, we have for a fixed period, whether it is a patent or it is a copyright, we get this property only for a fixed period, and that fixed period has got to be determined by the state, will have to be regulated by the state, but at the same time also the period which is within this regime needs to be properly regulated, so that the public domain is not allowed to shrink progressively as it is happening, and the people at large, the society at large gets the benefit of the advancement in the intellectual field. With these few words, I should conclude, and I thank you all. I thank the organizers for giving me this opportunity to share my thoughts with you all. Thank you very much.
I would request Justice Ravindra Bhat to hand over to Benzo. Thank you, Professor Rahman. Both the speakers highlighted different areas, but the concerns are the same. I wouldn't like to stand between your questions and both the speakers, except to take the last speaker's thoughts further. Professor Rahman spoke about need to harmonize human rights and intellectual property law. In the abstract, it sounds very easy, but even in the international sphere, in the sense that there are human rights related components, such as the Universal Declaration of Human Rights, International Covenant of Civil and Political Rights, which confer very important rights to life, public health, to access to education, etc. Those are very wide rights which have no exception. And on the other hand, you have trade law conventions like the WTO on the TRIPS, which also confer equally wide privileges to property owners. The only thing is there are still escape routes as compulsory license. States have very little elbow room to work their way around. And as yet, the WTO Chamber of Disputes has not resolved this issue. I think one of the cases, early cases before the WTO was what is known as Canada generics, where this partially this was argued, but it went in favor of property owners. But the heartening news is 17 years down the line now, public health and on the one hand and intellectual property on the others became the heart of a very important and a kind of a defining dispute, and that too was in the it spilled over several bilateral investment treaty arbitrations, and it also went to the WTO Chamber of Disputes. There is a separate treaty on tobacco, regulation. So some countries have come out with laws that mandate plain paper packaging. Plain paper packaging simply means that most of the packaging of these tobacco products like cigarettes will be on plain paper. So you cannot display your trademark, which means that your trademark owner's rights, they are directly affected. So the tobacco producing and tobacco product companies and countries which were tobacco producing, they sued countries which made these laws. I think it was Australia which made these laws. And this was a long pending dispute. The judgment, the award has come, which has upheld the plain paper packaging laws as not violating intellectual property laws or treaties. So that is it's a way out. What we are seeing is for the first time. But as students of law, you would know that we have the Vienna Convention on Law of Treaties. Now the Vienna Convention teaches you by Article 31 how to interpret provisions within the treaty, within a particular treaty, and in case of conflict. So that application of Article 31 has not yet been explored, and it's going to be fascinating, especially when we are talk of developing countries and their interface with intellectual properties and intellectual property laws in the sphere of knowledge, in the sphere of public health. I think with that I will sign off and invite any questions that the audience would like to put to the speakers. Yes.
So my name is Ajay Jose. I am a final year LLM student. My question is addressed to Imtiaz. There is always a conflict between the monopoly and public interest. That is the reason that advancement of IP hamper the human rights. So if we give more weightage to the public interest, it may use attention upon authors and honors. On the other hand, if we give more weightage upon the monopoly, it may curtail the public interest. So in what level we can harmonize this IP and human rights? Because this may stand in two different extremes. It is recognized in two different sectors. So in what point of level we can harmonize both?
Thank you for the question. It's a very good question actually, and also a very difficult one, because you see this harmonizing, it is not exactly a question of law. It is a question of policy, and ultimately perhaps to a very great extent question of ideology. What ideology you believe in? We have apparently declared professing a socialist state. If you read the preamble, so if you read the preamble, if you read the constitution, we find it a socialist state. Although of course, if we see the practice, it is difficult. It is difficult. So when you harmonize the two classes of conflicting interest, it depends actually, I think, to a very great extent on your ideology, on your policy. Whose interest you will give precedence to, and whose interest you will ultimately allow to serve whose interest. So here it is I think just a balancing act that one has to do, and I think in the context of our own country, particularly the rural population, the masses, the general masses, definitely I think we have to give our consideration more to that sector rather than the glittering class. So there it is to a great extent, as I said, matter of only our ideology, our policy, rather than anything else. Monopolies certainly should not be allowed in any society. It was never allowed earlier also, and it will not be allowed today. As far as the professed policy of law is concerned, although of course it is becoming monopolistic in certain fields, because certain giant companies, certain big players, they are slowly capturing the entire market, and therefore in a way they are establishing monopoly, although we may not accept in public discourse, but that is happening. But again, I have to simply say that how we will reconcile, that is a matter of policy, but I will only say that in this regard we have to take the interest of the larger section of the society first, and then we have to reconcile their interest with the efforts of the people who are working hard, with the intellect of the people who are working hard to produce these things. The law should serve all of us, the law should serve all segments of society, but as the respectable chairperson said, these things are easier said than done. But again, you have to do it, we have to do it, and how we will do it, to what extent we will give precedence to the interest of one section over the other, will always remain a matter of ideology, will always remain a matter of policy. Although we may have declared one policy and we may be following some other policy, when we see the letter of the law, when we see the letters of the constitution and the laws, we will realize that comparing the activities which are actually taking place. So that can happen. Always there will be a difference between the law in action and the law in books. That difference will be there, but still we should try to minimize that difference, that cleavage between the law in action and the law in books, and we should try to also bring our law to the people and ensure that the law serves the people, that the law caters to their needs, and then only there will be holistic growth. We may believe in growth, but no growth. I remember reading an article by Professor Amartya Sen some time back, when he said that unless and until we ensure growth of all sections of society, our growth will not be viable. Our growth will not continue for many years. Growth rate will fall down unless and until we involve all sections of society, unless and until we believe in holistic growth. He had given the example of China, and he said that there they are ensuring this more than what we are doing here. So therefore actually I think we must bear in mind this, otherwise our growth will not be a sustainable growth. It will not last for many years. The growth rate will also ultimately fall. Thank you.
Yes. Sir, actually we are falling short of time, so I guess we will not be able to take any more questions.
Right, thank you all. Thank both the participants and the audience for the patience. I think we have stepped into lunchtime, and it's also difficult for audiences to hold their concentration for this long. So thank you all. This was a wonderful session, and I think it will be always very topical for you to debate this. Thank you.
I will invite Professor C.R. Raj to give the vote of thanks.
Very good afternoon to all of you. Already we are running short of time. We are very late. I am very sorry for that. It is my pleasure to Ravindra Bhat and Professor Vivekanandan, Professor Ahmed, Mr. Vineet. On behalf of the IPR cell and on behalf of the law school, it is my privilege to propose the vote of thanks. Particularly, on my own behalf and on behalf of the IPR cell, SRIC, and the Rajiv Gandhi School of Intellectual Property Law, I express my sincere gratitude, particularly for the two judges who travel, particularly Honorable Judge Ravindra Bhat. He traveled all the way from Delhi upon our request. Thank you very much, sir, for being with us. And I also express my sincere thanks to Professor Vivekanandan and Professor Ahmed and the patent attorney, Mr. Vineet, for spending your time today with us to educate our students how to draft the patent and the legality of the patenting. And the event of such things cannot happen in overnight. The wheel has to roll weeks or months. We have a backbone of a team, the organizing team, including the young students. The morning they have presented technology transfer group, the heads, the coordinators, and of course our organizing team, including the MHRD IPR chair, Professor Goutam, and the law school faculty members. I would like to thank all of them for helping me and to organize this event in a grand success. And more importantly, to organize such an event, we need a support from the institute. When I contacted the director and the dean, they wholeheartedly given the whole support. In fact, Dean Sirik wanted to be here with the students, but he had an important engagement. He said that, I'm sorry, I will not be able to come. So I thank all of the institute authorities for providing the sufficient support, financial and moral supports. And the supporting staff, particularly the IPR cell secretary who will be sitting there, Mr. Anjan, and our SRIC team, Mr. Smith Biswas, deputy director, and the staff members of the SRIC. I would like to express my sincere thanks. And the audiovisual supporting staff, and the auditorium and the caretaker, and particularly I should mention the horticulture. At the last moment, I wrote a letter to the executive engineer, B.B. Roy. I did not get a reply, but finally they gave us the plans. So I sincerely thank them, and the sanitary section for providing this facility in the auditorium. And of course, I would like to mention the video recording and photography team for being with us from the beginning. We had a little bit of doubt how we'll be able to make it, but they are here before we arrive here. So on behalf of the organizing team, I express my sincere thanks to all of you. If I missed any of you, please forgive me. Once again, I express my sincere thanks to the organizing team, all the law school students, and of course, the research scholars from the different departments. Before I conclude, I would like to mention a few lines. I will not take more time. As a professor in charge, it is my duty to advertise the patent portal. We have seen the registration, and some of the students are ready with the invention to file. So this is for the students. We have a patent portal, and you can disclose your invention through online. You can contact our TTG students, they are available, and of course, the IPR cell secretary, Mr. Anjan Bhaumik. You can contact us at any time, we are here to help us. We have a wonderful platform of disclosing your invention. There are formalities there. You can write briefly. In case if you have a doubt, you can approach us, either the TTG student or the secretary or myself or the law school faculty members. We are ready to help you to draft the patent. and you can submit online, and this will be reviewed by two experts, one from the legal and another expert domain. So, the legal expert comes from the law school and another one experts from the domain, where say for example electronics, the electronic faculty review it, and then it comes to me, I will take the final decision, we will send to the patent attorney to final drafting and for filing. So, we are here as IPR cell at the team with the IPR cell and the legal team from the law school. I would like to mention the name, right, Professor Motilal, Professor Badma, Professor K.D. Raju and Professor Tapas, and many other faculty members including Professor Uday. So, we are here to help all of you. It is my desire that all the students come forward to disclose your invention, to take our institute the patent number to high level. Once again, I thank all of you for your patience. Thank you very much.